Hello, everybody. Great to see you all. Hello, Nana Laura. Hello, Wixom01. You were close. You're first in my heart. How's that? Hello, Michelle Moreland. Hello, C-Rex. No big ol' yawn from a big ol' baby. Hello, Sobe Liz. I'm trying. Hello, Spider-Man. Ava, please. Hello, sweet home Alamanda. Thanks for coming. Hello, Ginny. Hello, Nigel1701. Joey Bag of Donuts. My love. My dear sweet friend. Hello, Barbie. My faithful waver. Hello, CE. Hello, Army Brat 1964. We've missed you. The spoiled, rotten babies of the PAWFURM have received mail. I am certain of it. This was my clue. Ava, I know it's for you. They know it's for you. You know it's for you. Can you give me that other box, Ava? Go get it. It got away from me. Sweet home Alamanda, thank you. Thank you so much. Oh. Jean Chavez, thank you so much. I'm so happy you made it. Yahoo! That was actually what their advertisement did. Yep. And I think I'm pretty sure the rattle that they make, when I pick them up, it sounds an awful lot like biscuits. Not even a little bit. She doesn't even have a lick of retriever in her. Yeah, that's exactly what it is, too. My goodness. Not spoiled at all. Not spoiled at all. Not even a little bit. Just regular old dog right here. Hello, do you mind? She doesn't. She doesn't mind. But she knows what this is. And they're baked beef. She has not had this flavor yet. Thank you, Uncle Joey. Oh my goodness. Oh my goodness. You wouldn't think she wants him or something, do you? She's been out for a little bit. If you haven't noticed out there, she's been kind of out of them. Beef. It's apparently what's for dinner. And get her other two ready to go. Did you taste them? Did you even taste them? She looks like a puppy. She looks like a puppy when she's getting her treats. All right. This one feels awfully suspiciously like something similar. Ooh, there's stuffing in this package. But, like, not in the package, in the liner of the package. It's our pumpkin and cinnamon bars. Yay, thank you so... Oh, my goodness. It's a twofer. It's a twofer. You are so triply spoiled tonight. That is unbelievable. I know there's one more up here. You know it too. Oh my gosh, thank you so much. And then there's also a box. Yes. This one has my name on it. But do you think it's going to be for me? I doubt it. It feels very feline. But that's okay, because you know what? When these guys are happy, life's so much better for me. Did you know this one was going to be yours? Is that what this is? Ava knows when it's hers. Billy knows when it's his. Oh, wait. You know what? It is actually for me. But it's not a gift. It's a moisturizing cream. I was not expecting that. Okay, it's okay, Billy. Don't worry. There's plenty of treats for you. You have boxes. You have bags. You have lots of treats. You're going to be okay, buddy. Oh my goodness. Thank you so much, Joey. And the other gifter. You know who you are. Oh, Nana Laura, you are so sweet. Thank you. I love you guys so much. Michelle Moreland, you are just amazing. Thank you for being so wonderful to me. Hello, Sir Philip. Oh, hey now. Be nice to my dog. Be nice to my dog. My dog that got in a fight with a possum the other night. Yes, she did. I was not happy about it. Possums are such amazing creatures. They eat thousands of ticks. I want them. around my dog. But she wasn't having it. It played dead. It didn't actually fight back. It played dead, and then I managed to hold the leash at bay. I pet the possum a couple times to make sure it was okay and to calm it down. And then when I went to put Ava in the kennel outside, where the possum had climbed up in to eat Billy's food that was in there, it climbed down the deck and jumped into the rocks. So it was okay. It was okay. And I poured some food down in a safe place that Ava can't get to, but the possum can very easily. When the video's going, I promise I'll give you licky treats. Colette McCoy. I don't know if I said hi to you yet or not, sweetie. I love you. Thank you for being here. Hello, Sean Old Fart. I love that name. I know a Sean, and he's an old fart. And he's gonna message me in a minute and say, I heard that. Oh, hi, Karen. Oh, hello, Karen. Oh, sleep sweet, Nigel. Thank you for coming. So I just wanted to let you guys know. Stop that, please. I'm in a very important announcement. Okay, you go there. So I might take a few days off here and there. Someone that I love very dearly, he would not want his info put out there on the internet, but a very close family member of mine is going through some really significant medical struggles right now. And let's just say I might need some time off. So there might not be as many replay crew videos. There might not be as many, like I might need a night or two off during the week. That's actually what happened last night. So I just wanted you guys to know I'm not I'm not backing away from the channel or being lazy or anything like that. It's pretty serious family stuff. So, but hopefully things go well and I can get back to normal. Right, Billy? Thank you, Barb. I really appreciate it. Billy's been sleeping on me since it started. Yeah. Oh, thank you, baby. Well, you're my family too. This one just had a more significant role in my existence. So, but yeah, and also the case, my computer, that one. Hey, I am not edible. my main downloading and editing computer, for some reason, is taking quite literally 2 hours or more to export videos. So, happy birthday, sweetie. So my I hit export almost 2 hours ago, and it's at 89.8%. So we're gonna have to court crawl. We're gonna have to go, I don't know, I'm thinking maybe Reno. Since forever. Forever. Oh, hi, Rocky Lennon. Welcome, sweetie. So as soon as the case is done, it's at 90.5 now. So it's maybe starting to pick up a little. Oh, this is where my great editing skills comes from. Oh, this goes right, hand in hand with that. Yep, field trip to the court crawl. Well, I'm 41 and I feel 60. So there might be some truth to that. You will get licky treats when the case starts too. I promise I won't give them to Billy without sharing. Oh, these kids. All right, so let me go real quickly. And of course, my typing ability is suddenly very limited. You're gonna lay there. Okay, thanks. Hey, buds. Hey, that tail needs to stop before you kick me out of my stream again. Okay, I'm trying to remember which one it was today. I think, was it 1? Yes, it was 1. All right, here we go. Dun, 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 dun. Gotta make sure I do this in the right order, because if I screw it up. There we go. Yay, I did it, I think. Ooh, she looks excited. And our judge has glasses on.
Is it good? Is it good?
Hi, Judge.
Yeah.
Hey guys, can you hear me? I'm having a little bit of technical difficulties today.
We can hear you.
Okay. This is Iris, by the way.
I'm kidding.
I was like, Judge, are you kidding me?
I knew it.
I had you going. Okay.
Oh my God.
Kathy, say something. Or we don't have any pleas today. So let's start off, even though I just reviewed it about an hour ago. Let's do it again. Marisha Kumkowicz.
She was actually uncooperative, Judge. If there's any way that we could start out with Llamas and Roseman, and then we have 3 people that will not be present: Komkowicz, Creighton, and Doe.
Okay, let me try to go down the list. So Komkowicz, we'll keep it at 250 bail. Antonio Creighton.
He's not here.
He what?
He didn't show up.
Okay, we'll keep it at $2,500. Jane Doe. Got it set
She
at
didn't
five.
show up.
Oh, keep it at 500. You know, with that name, you think she could probably afford it. Why?
Doe.
She's got Doe. Yeah, okay. Maybe Ray and me could help her out. Heather Dyer. 2,500 bondable, second time DUI. Kathy, you got an argument?
I do. She works at Renown in Billing full-time. Her NPRI was a 5. She's willing to wear a scram or an OSM. I know that there's another DUI close in time, but she's willing to do everything she needs to do, and I'd be asking for her release on her recognizance.
Iris,
May I respond? Yes. Okay, so second time DUI, Your Honor, this is extremely dangerous to the community. My question would be, was she wearing a scram before? Do we know, Kathy?
I don't know.
when was the prior DUI?
October 2023.
Oh,
So just,
okay.
yeah, just within the last year.
Yeah.
I understand that she has a good job and we don't want her to lose that, but the city's concern is the danger to the community. We also have a second charge of driving on suspended revoked license. I realize that there may be some, I don't know exactly what's going on with that because you know how sometimes we're outside of that revocation period, but regardless, we have a DUI second. 2,500 bondable is really low for a second time DUI.
What was the BAC? Do you have it?
I don't have that. Do you, Kath?
No, it was a blood draw and I couldn't see a PBT.
Okay. All right, Ms. Dyer, I am going to keep it at 2,500 bondable. You make that bond, you report upon release to the Reno Municipal Court. You'll be on enhanced supervision, which means you'll be testing a lot. Obey laws, no alcohol, no drugs. This is for your own good. Good luck. And we got you a legal defender. Okay.
And
Alex Lamas,
the 2,500 is it? What's the minimum for that?
that's bondable. You can go to a bondsman. I think you have to pay them 15%.
Okay.
And Your Honor, just to add to that, if she's able to make that, I would request a scram be placed on her as part of a condition of her release.
I think you're right. There would also be a scram, young lady. You're right on the doorstep of a felony. You've got major problems. In fact, I might be seeing you in a specialty court. So it'll be enhanced supervision, a scram unit, obey laws, no drugs or alcohol. Do you understand?
Yes.
All right, thank you. Good luck. Okay, Alex Lamas.
Morning, Your Honor.
Good morning. We've got 2 warrants. What are we going to do? Kathy, your thoughts?
Your Honor, on this case, though, it's a driving without a valid driver's license, unregistered vehicle. So I would be asking for his release on this case on his own recognizance. He works construction for Dan Mills, and he's been in Reno for a little bit of time.
Irma? I'm Irma.
That's okay.
Yeah,
The other person with the I name.
yeah.
So here's my concern with this. 2,000 bondable, which is what that preliminary bill was set at. I think we could go down from that. However, since there are 2 other warrants, that makes me concerned that there might not be an appearance for court. Looks like he's set for Monday for, I don't know, do you know, Kathy, is it for something else or is it for this?
I can't tell. It's for the 2 warrants.
Okay.
This is what we'll do. We'll keep it at, I'm going to make it $1,000 bondable. Despite making the bond, if you made it today, you'd still be in custody for the warrant that's going to be addressed next week. So I'm taking it down to $1,000 and it will be bondable. Thank you, sir.
I got a question. So if I make the $1,000 today, can I be released?
No, what I just said is that you've got 2 warrants, which also has a bond on it. So I doubt so. You'll be seen Monday as far as the warrants are concerned.
Yes, sir.
Thank you. All right, let's go to Carson Miller. Operating without blah, 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 blah. Tamper with breath interlock device. You there, Mr. Miller?
Yes, I'm here, Your Honor.
All right. This is what I'm going to do, young man. I'm going to go an OR on this one, Iris. It's a whatever case.
Your Honor, may I just sort of
Yeah.
object respectfully to that? Here's the thing. Operating a vehicle without or tampering with breath interlock device. So we have someone who has a requirement for a breath interlock device being alleged to have been either driving without it or tampering with that. That's extremely dangerous. Why was this conduct occurring? We don't know, but based on the allegations, it would seem like somebody may have been trying to get out of driving under the influence. Do you know what I'm saying?
I
So
do.
I would request the bail actually be increased in this case. Or if Your Honor isn't inclined to do that, I would respectfully request that maybe we do a scram or something. I think that we need to protect the community in this case because of what's actually going on.
Okay. Kathy?
Your Honor, I would oppose that, and I'd be asking for an OR release. And looking at the report, there's nothing in there that talks about this gentleman having any alcohol on board or anything else, or how the scram was. It said that what it says is he advised his vehicle did not have an interlock device. There's nothing about tampering with one. So what I would be asking for is the court to go back to originally what the court was going to do, which was an OR release. And because if you look at this gentleman's MPRA, it's the 6th, but he has an address which they listed in the report on Golden Spike. If you look at that, then the 6 that he has drops down to a 4.
Let's do this. Excuse me, Kathy.
Sure.
Mr. Miller, I'm going to give you that OR release. I don't want to make any assumptions on this, but what will happen, you get out of custody, today is Saturday, you show up on Monday, and you report upon release, no alcohol, no drugs, and I want an OSM on you. You're walking a fine line, young man. If there was any alcohol involved, I would have taken the bond up further. Do you understand me?
Yes, Your Honor.
All right, that'll be the order. Good luck. Don't screw this up.
Thank you, Your Honor.
Judge,
Yeah.
he will be here for his arraignment on October 16th at 2:00 in the afternoon.
Okay. Thank you. All right. Let's go to Oscar Perez. Okay. Iris, we've got trespassing and we've got a 2023 DUI. We've got a February 24 inmate assistance program and men in custody. Okay, anyways, what do you want? What's your thoughts?
So my thoughts are this, yes, it's a trespassing. Trespassing is not a particularly aggravated charge on its face, but it could be depending on the circumstances. I can tell you it looks like there may be some mental health issues. He was not able to get into COD court or mental health court. I'm looking at the notes here, remain in custody until directly transported by IAP to a program when a bed is available. Are we looking for treatment for him, Kathy?
I don't know where you're reading about the IAP bed is available.
Let me make sure I have the right person.
I don't see that. What I know about Mr. Perez is he's employed in 2 jobs. He works in a landscaping business, and he also works at a moving company. The reason he said that he was unemployed was he was really embarrassed by this. And what I would be asking is an OR release so that he can come to court.
So what I'm looking at here is you and I, Kathy, were sent some notes related to certain people. We were both sent that, so we all have the same information. It was sent by email. My main concern, like I said, it's not really the trespass on its face, although I would request a stay away from Winco, but I want to know what's going on. I want this person to get help. And maybe we can address that once we get to the point where actually the plea. Maybe I'm putting the cart before the horse, so to speak.
Let's do this. Mr. Perez, are you there?
Yes, Your Honor. I'm here.
Okay. Now this is the deal. I'm going to give you an OR release. You're going to report Monday to the Reno Municipal Court, and there's going to be a no contact order with Winco. Do not set foot on Winco. And another condition that you obey all laws. Martha, can we get a court date for this individual?
It will be set for October 16th at 2:00.
All right, obey all laws, no contact with Winco, sir. You're in charge of your destiny. Do you understand me?
I understand that, Judge Track. Thank you.
All right.
Thank you.
Okay, let's go to Edgar Picos Millen.
Gotcha.
Okay, I've got.
How does he expect people to obey all laws? I mean, really? That's just asking too much.
Millen.
Gotcha.
Okay, I've got DUI, 1,500's already been set, LD's been granted. Variance from that, Iris?
The city believes that $1,500 is more than fair. This is a DUI. DUIs pose a danger to the community, Your Honor. I would ask that supervision be imposed in addition to this bail.
Okay. Kathy?
Your Honor, what I would be asking is for Mr. Picos Millen to be released on his OR. His NPRA was a 3. That's a low number. He works as a landscaper. He's willing to wear a scram or carry an OSM. I think that's where the protection of the community lies, not in a bondable bail.
All right, Mr. Picos Millen, I'm going to keep it at 1,500. You make that bond. You report upon release to the Reno Municipal Court. You've got a legal defender granted. Your pretrial conditions, young man, obey all laws, no alcohol, no drugs. Do we have a BAC by chance?
I was just trying to look for it and I am not able to locate it. Do you have that, Kathy?
No, I think this was a blood test.
It was a blood also.
Okay, that'll be the deal, sir. I'm keeping it at 1,500. You make that bond, report upon release Monday. No alcohol, no drugs, obey all laws. Martha, legal defender information and trial date.
Judge, if you put bail on it, so he has to post the bail.
Yeah. Oh, I got it. Okay. They'll take care of that when you do that. Thank you. Don't get old. Shauna Roseman. Obstructing, resisting an officer, bond set at 750. Iris?
Your Honor, as you know, O&R, this is a non-compliance. I don't have a good access to all of the circumstances, but I do know that it's a non-compliance, which can be extremely dangerous to our officers, to the community, just based on what happens. We're not talking about a simple misidentifier or something like that. You did the preliminary bail at 750. The city believes it should remain at that so that we can protect all parties involved.
Kathy?
Your Honor, Shauna is a participant in community court. So what we'll be we would be asking to do is to have this, have this case brought over. As far as bail, she does not have a fixed address, and there's no way for her to make any bail. So I'd be asking for OR release.
Right, Ms. Roseman, I'm going to keep it at 750. You make that bond, report upon release to the Reno Municipal Court, and obey all laws. Thank you. All right, let's go to Ruben Tapia, T-A-P-I-A. Open container. Oh my God. I know. Did I set that at 500 bondable?
You did, Your Honor. And can I jump in?
Yeah, go ahead, make it because
Because it's an open container and it's an open container, I have no objection to an OR release as long as there's supervision. The main concern is getting him into court. I don't necessarily see a danger to the community other than the fact that if he was drinking and crossing the street or something, he could be putting people in danger, but we don't have those facts in front of us. We just have an open container.
My computer was screwy this morning and I had to do a lot of these telephonically. Mr. Tapia, I'm going to give you an OR release. Now
Okay.
you're going to report upon release Monday to the Reno Municipal Court. Your pretrial conditions are obey all laws, no drugs or alcohol. Do you understand me?
Yes, Your Honor.
That'll be the order. Thank you.
His
Okay.
court date is October 16th at 2 o'clock.
Okay.
Okay.
Michael Wood.
Thank you.
You can go ahead, Barry.
Michael Wood is set at 1,500. Is Mr. Wood there? Iris?
Your Honor, this is a DUI charge. We don't have a BAC because it's alleged a possible chemical impairment. So at this point, based on the danger to the community, being that it's a DUI charge, the city would request the 1,500 bail remain exactly where it's at. And that's in the city's assessment, actually pretty low.
Okay. Kathy?
Your Honor,
Let me guess. OR? Oh, go ahead.
how did you know?
I'm minor.
This is so his MPRA score is a 6. It lists that he doesn't have a residence on that, but he does have a residence at Lake Mill, which really makes it a 4. That's pretty low. He's willing to have a SCRAM bracelet or an OSM. He's willing to check in with the court. He's willing to go to Sober 24 and do the drug testing prior to trial. So I would be asking for an OR release since he's willing to do those those things. Also list the number 6 of the NPRA that if there have been no FTAs in the last 24 months.
All right, Mr. Wood, since it is a DUI, it's a minimum that I put it at, and I'm going to keep it at that. It'll be $1,500 bondable. You've been given a legal defender. If you make that bail, report upon release, no drugs or alcohol. Thank you, sir.
And guys, just real quick, because of the possible chemical impairment, I know we have a lot of difficulty testing for this type of stuff. Do we have any idea how we can test for that? Because I know we can do drugs at Sober 24. I know we can do alcohol, but if we're talking about something such as those like whippets or whatever
I think Sober 24 will pick that up, won't they?
I don't know.
I think that's our best bet, Your Honor. I think I remember in the staffing that I heard that they can test for that. We have to ask for it, but they can test it for that.
If we can ask for it, then we're doing our due diligence. I just want to make sure that we cover as many bases as we can with this.
Good.
I thought those were out of a person's system really quickly. I might be wrong. I know the effects of them are over really quickly from what I've heard, but I don't know how long it stays in your system. For those of you who don't know, you know those little nitrous oxide, I think that's what they're called, the little metal containers that when you puncture it, yeah, apparently people use those to get loopy.
Okay, let's keep it at that then. You'll also be subject to testing, and the testing will be determined by the court. You'll be referred over. All right, thank you, sir.
Thank you.
God, this is it? You're done. Thank you.
I think there's Alex Yamas or Lamas.
Huh?
Is there Alex Lamas or did he leave?
He was actually seen earlier.
Oh, sorry. Forgot to mark it off.
God, I just hate it being so quick. It's so wonderful. Hey, Martha, take us off the air.
Yeah, give me a minute, Judge.
Okay.
I just love that guy. He's so funny. The dad jokes, they're just, I'm a dad jokes kind of gal. Okay, I'm an any jokes kind of gal. I'm not picky. Hello, Mortimer Duke. I'm just getting ready to put on the next round of cases. Sometimes, yeah. And for those who can't tell, this is the version of Whip It I have around here. Oh, aren't you lucky?
All right, calling case number 24-004-027-01 People of the State of Michigan versus Chance Bond. Parties, your appearances, please.
Good morning, Your Honor. Patricia Mander, Deck for the People, P84088.
Yeah, good morning, Your Honor. Robert Terzic on behalf of Chance Bonham. I'm appearing by Zoom, and I believe is he there in the courtroom, or is he on Zoom from the jail?
He is here in the courtroom.
And I'm sorry to interrupt, Your Honor. Do we have a complaining witness, Brandy Malone, in the Zoom waiting room?
Yes, we do.
Thank you. I would just ask that she be admitted so she can observe.
Sure.
Thank you, Judge.
All right. And Miss Malone, let's see. Well, I guess if she's not stating anything, she doesn't need to state her appearance. Okay. So we are here today for a final conference in Mr. Bonham's matter. And where do things stand at this time?
Your Honor, I recently conveyed an amended plea offer to defense counsel. The current plea offer in this case is that defendant pleads guilty to count 2, assault with intent to do great bodily harm, less than murder or by strangulation. In exchange, the people agree to dismiss counts 1, 3, and 4. Additionally, 34th District Court case number 24-0675-FY, which is an aggravated stalking case with the same parties stemming from a bond violation. In this case, that the egg stalking case will be dismissed as well. There's a sentence agreement. Defendant would be sentenced to 3 years probation, first 6 months in the Wayne County Jail. Defendant must complete DBT. Defendant is eligible for early release upon completion of DBT. Defendant must complete substance abuse evaluation and any recommended treatment, and mental health evaluation and any recommended treatment. No contact with Brandy Malone except pursuant to a custody and parenting time order, any other terms and conditions ordered by the court.
All right. Thank you. And is that a new offer, or has defense received that offer previously?
I conveyed this offer to defense a couple days ago. It's just a brief, the only term that was modified is it went from no contact with Brandy Malone to no contact with Brandy Malone except pursuant to a custody and parenting time order. Complaining witness is currently pregnant with defendant's child.
Okay. All right. Thank you. And what's defense's position at this time?
Your Honor, I've spoken with my client, and he does not, and at the last time I spoke with him, he does not wish to avail himself of the offer made by the prosecution.
Okay.
Unless Mr. Bonham has reconsidered or changed his mind since then, I'm not aware of.
Okay. So, Mr. Bonham, is it still your wish to proceed to trial, sir?
I have a question before I answer that, if I may speak.
Yes, I just, it's not about the facts of the case, is it?
No, sir.
Okay. All right, then.
So on August 1st, this motion was put into the court where you granted my bond with the conditions, correct?
So let's see here.
250,000 cash for surety with GPS tether, curfew 10 to 4 a.m. No contact with complaining witness. Cannot return to protected address.
Yes, that is what I have.
So I attempted to post said bond and was told that I did not have a bond. So I've been here for the past 44 days. And 9 of those days, I haven't had contact with my attorney or my family. I've been assaulted. I have a fractured hand. So before I even proceed with this, I would like to ask that I can have some type of bond so that I can, at the very least, make some money to take care of my child. I'm on the verge of losing everything. House, a car, there's only so much grass that can be cut before the season is over. I've missed out on all of that. So I don't know how that plays in this situation. It's not that I'm not wanting to take the plea. I just want to take care of my affairs, see my son be born, and then I'll gladly sit for 6 months if necessary.
Okay. Well, as far as the plea offer, that I'm gonna leave for you and Mr. Jurzik to talk about. But as it relates to your bond, I don't know why. So was it a bond bailsman that told you they didn't, that you had no bond, or was it someone from the sheriff's office?
Both.
Both.
My bond, when I went to post my building, they told me I did not have a bond. Whenever I spoke to the new attorney that is representing this new charge that they're trying to force me into as a condition of taking this plea, she also told me that she can see right there where this paper has been filed, where the motion was granted, but in their system, it still says that I'm remand. So I was not able to post my bond.
I don't know why I would say remand, because I see. Now, is that the Corporal Brzezinski, is that the order that he has in his hand?
Yeah, that's the bond or motion or bond motion.
Now, when they told you that you did not have a bond, did you happen to have that with you?
Yes, sir.
So you showed it to them, and what did they say?
Showed it to them.
Well, okay, so someone told you do not, there is no bond that you can
So
post.
the bail bondsman.
Did you
said
show
that.
them that order?
Yes, the bail bondsman said that. I read this to my family who conveyed it to them. They told me that to the best of their knowledge, that the best that they will be able to do is on yesterday's date at that court proceeding, that it will be addressed. When I talked to Miss Tamika Tucker, she confirmed from what she could see that I was still remanded.
In both spots where I can look at bond in our system, I do not see that. What do you see in your?
So this is just that I use, but they do have some kind of remand for something here. I don't know what the saying what, but there
What is
is
it
a
for-
remand. I don't know
What
what
is
this
that? Our, let's see
bond.
if that's our 7.
I don't know what this bond number is though, because it's not.
Right, those don't
case
match
number.
up with the cases.
Case number is here.
And that doesn't make sense because our bond is not either of those. So it's a 250,000 cash shirt.
So does he have 2 cases?
He does have a second. So your second case is at 34th District Court, was it?
Yes,
Not
Judge.
arraigned.
Defendant has a second case at 34th District Court. He's charged with ag stalking. As I indicated earlier, stemming from a bond violation. In this case, I won't go into more detail unless the court would like.
Oh, I bet that makes a big difference.
That case, we just had the PCC for it yesterday. Or I'm sorry, not yesterday, Wednesday, September 9th, 2024. And that's currently set for a preliminary exam on October 23rd, 2024. And I would like to address the possible joinder issue with the court when the court.
Are you the prosecutor on that case as well?
Yes, Judge.
Do you know what the bond is in that matter?
Yes, Judge, I have it up in front of me. In that case, defendant was given a $10,000 PR bond.
May I speak?
Yes.
I have not been arraigned on that matter. So I just don't understand how that makes a difference. Because that wasn't filed before this date, to my knowledge and my understanding, unless you guys know something that I haven't been privileged to.
So what you're saying, you have not been arraigned on that case, but you
No,
said
sir.
didn't you say there was a PCC yesterday?
Yeah, Judge, we just had a PCC for the ag stalking case yesterday where we set it for an exam on 10/23/2024 at 11 a.m.
When I asked the judge, she told me through her mouth, I am not being held on that matter and that it was to be reviewed. I have not been arraigned in that matter. I have not seen a judge. I sat down. She told me that it would be reviewed and I walked away. I never gave my name. I never gave a testimony, a statement or anything of the such. I was never arraigned.
Okay, well, I'm gonna leave that. The people are now aware of that issue. I'm gonna leave that up to the district court. But maybe the people can raise that issue if they'd like to rearrange you. As it relates to bond issue in this case, no, Corporal Brzezinski, is there anyone that could maybe tell you what that bond number is associated with, so we could try to figure out why?
Well, I have a potential remedy. I have the MIT. and
Okay.
I have the order, the same copy. I have the clerk print me another copy. And when I take him back over there, I will make sure that the computer reflects this order. I don't know if it was just a clerical thing and it didn't get properly updated. I
Okay,
don't know. I don't
okay,
work over there, so I don't know, but I will personally make them pull it up and enter in this in front of me,
okay.
if
All right.
that'll help.
Yeah, oh, yeah, no, that would be very helpful. Thank
Your
you.
Honor,
Yes,
can I please have a 10%? Is that possible so that that's something I can manage? If I pay this money, that's $25,000 that I don't have, that I'm gonna have to borrow. That is more food out of my child's mouth. At 10%, I can manage it. I can do what I need to do, get my affairs together, and I will sit here in Wayne County Jail for 6 months with a smile on my face, knowing I've done what I need to do as a man, with your grace.
Judge, would the court like the people to respond?
sure, yes.
Your Honor, in this case, the judge set the bond as it is, because, and I'm sorry, Judge, my notes just disappeared. The court set the bond so high in this case because of the aggravated stalking, in part because of the aggravated stalking case where defendant came to complaining witness's home in violation of the no contact order. If I recall correctly, we have defendant on ring camera video, and defense counsel can correct me if I'm wrong. We have defendant on ring camera video, attempting to enter through complaining witness's front door. When he fails to enter, when he can't get through the front door, he goes around to the side of the house, which is where complaining witness's bedroom window is. He bangs on the door. You can hear him telling her to open the door and demanding entry into the house. In the ring video, he does this a couple times in the middle of the night. I believe it was at 2 a.m. And then the next day he comes back in the afternoon when complaining witness usually leaves for work, and again attempted to enter through the front door, failed, and attempted to enter, and then went to complaining witness's bedroom window. Additionally, Your Honor, during this incident, during the case in front of the court currently, when defendant was assaulting complaining witness, defendant told complaining witness is currently pregnant, as I stated earlier. She's due in November. Defendant stated during this case, when he was assaulting complaining witness, that he was trying to induce an abortion in her. And additionally, Your Honor, at 34th District Court at the date scheduled for the preliminary exam in this case, defendant approached complaining witness outside of court and asked complaining witness what happened to not showing up to court. We had a bond hearing at the 34th District Court on the day of the exam. During that hearing, defendant admitted that he had been living at complaining witness's residence for a period of time in violation of his bond. Defendant had multiple outbursts on the record where he admitted to having contact with complaining witness and expressed that he felt entitled to have contact with her because she is carrying his child. As the court knows, in domestic violence cases specifically, the lethality risk for a complaining witness skyrockets when the complaining witness is pregnant and soon after birth. So based on defendant's conduct of violating the no contact order by coming to complaining witness's house, his conduct of approaching her at the court, at the 34th District Court, and asking her what happened to not showing up to court. His own admissions on the record multiple times that he has violated his bond, and the fact that he has expressed that he feels entitled to contact with complaining witness despite the court's orders because she is pregnant with his child. I would ask that the court keep the bond as is for the safety of complaining witness.
That sounds like a whole lot of witness intimidation.
May I rebuttal, Your Honor, please? If you
Yeah,
may.
briefly, yes.
So I never had an outburst the same way I'm talking to you as I talked to Judge Oakley. He asked me a question, I answered it. I gave him a specific answer to his specific question. I didn't lie, and it's not as though the prosecutor is trying to paint it. My attorney was present, and all of these matters are on the record. He asked me a question, and these videos that she is referring to have never been played in an open courtroom. I've never been arraigned on them. To my knowledge, they don't even exist. I have not received the discovery. I feel as though I'm being railroaded, and I don't think that's fair. And you, in your motion that was granted, you said a GPS tether. With a GPS tether, I have no way of going there. I have no intention on going there. I would like to work and pay what needs to be paid for my child only.
Okay. I understand both parties' positions.
And one more thing, Your Honor.
Okay.
Can
Yes.
we address the emails that were sent over? Because last that I was told that the complaining witness was not wanting to come to trial. That's what was shown to me. And so if I'm such a risk, why is it that my complaining witness is asking that I'm released so that I can take care of my child? Mr. Jerkins, can you please read the emails that you displayed to me?
Yes, I received an email in which the complaining witness has stated that she didn't wish to pursue this matter. In fact, she had stated that she didn't wish to pursue this matter.
Well, that may
Can
be
you read
the
it word for word verbatim, please?
Hang on a second.
These are emails that were sent from the prosecutor.
I'm sorry, Judge, could the court possibly advise defendant of his Fifth Amendment right?
I am aware of my right to remain silent. Thank you very much. I would like to speak with my attorney. He's not present, so I'm speaking on my own behalf.
And additionally, Your Honor, I would ask the court to direct defendant that I am not allowed to speak with him or respond to him.
I addressed it to you, Your Honor.
okay. So
my apologies.
So I do want to remind you, I know you just
Yes,
stated
sir.
that you're aware, but you do have your Fifth Amendment right.
Yes, sir.
And yes, you cannot speak to the prosecutor directly. Those communications need to happen through your attorney, Mr. Jurczyk.
Yeah, he said just hoping there is a plea deal change because I won't be there for trial. I have personal things going on with my kids. And I'm still working 7 days a week. I don't have family or friends. I don't want to have his baby alone. He deserves to be there for the birth of his son. I know this man. I'm not dismissing what happened, but he needs help, not sit in jail. I don't
Okay.
believe he needs jail time or be kept from his son. I truly believe he needs therapy because I'm begging that you guys will dismiss all charges under the circumstances and that he does and takes anger management, sustains and maintains employment for a consistent schedule and mental emotional therapy, and give him time served anger management, employment therapy.
Which are all things that I will gladly do with the grace of you.
Okay.
And
So
I'm sorry, Judge, may I just briefly address the email?
yes.
Your Honor, I forwarded the email to defense counsel because I know we say this all the time. Our office is an office of justice and we operate in the sunshine. So of course, upon receipt, I'm forwarding that to both of his attorneys. I spoke with complaining witness. These emails were sent. The last one was sent from complaining witness Monday, September 9th. I spoke with complaining witness at length on Wednesday, September 11th about this case. I confirmed that she's on board with the current plea offer. I confirmed that she still wants to participate in prosecution
All right, thank you.
in both cases.
Excuse me, Your Honor.
Well, I think, Mr. Baum, at this point, we have allowed you to speak quite a bit, but I think I'm gonna leave it to Mr. Jurzik at this point.
That's what I want to ask a question towards him. I don't know how to do that without him being present. That was my question.
You have a question for Mr. Jurzik?
Yes.
Can I
Okay.
speak?
That was my question, was if she could speak.
No, Ms. Malone,
No,
I'm sorry.
Yes, typically we do not allow complaining witnesses to speak until.
My apologies.
It's okay, Ms. Malone. I know you're probably not familiar with the court process, so that's quite all right. Mr. Bonham, we will allow you to ask Mr. Jurzik one question before we close this matter.
That was my question. I was wondering.
Oh,
was able
if she
to
could,
speak on
if she was
her own
able to.
behalf.
Okay. Not today. That would, the complaining witness, we reserve their speaking until the time of trial when they would testify, if we get to that point. So thinking maybe we should return just once before we have our trial coming up on September 30th. I think maybe we should all be here in person on September 27th, if that works for everyone, just so that we can have one final meeting before we proceed to trial that following Monday.
May I ask one last question, Your Honor?
Yes, Mr. Baum.
Is there any way that I can be released between now and trial? I've tried everything that I can do in my power. And I at this point, it's not worth me to spend $25,000 to only have 3 weeks of work. I have somewhere to go. The GPS tether, I think, is sufficient.
I understand, Mr. Baum, but I've made my decision as it
Understood,
relates to Baum.
but I just had to ask. I appreciate
No,
it.
that's, so we will come back. So Mr. Jurzik, are you available for a final pretrial on September 27th?
I think that's the Friday before, yes.
Okay. We'll all appear in person that day. That way we can go over any final issues as it relates to trial or potential settlement. Anything else though for today?
No, Your Honor.
Anything on behalf of defense?
Not this time, Your Honor.
Okay. All right. We will see everyone back in 2 weeks from
All right.
today on September 27th. Thank you.
Thank you, Your Honor.
Okay, thank you.
Yeah. That one was. Oh. And I don't trust him for a moment. There was so much going on with that witness. She's pregnant. She's clearly locking her doors because he tried the front and the back. He wasn't able to get in. She didn't want him there. There's no contact. And yet you're getting statements like, what happened to not showing up to court when she comes to court? Like, that's scary. Absolutely. Yes, absolutely. Yeah, he's so Darrell Brooks minded. Watch. Give it. Well, we're going to see him back in court on some kind of violation or something, and he's going to have become a soft set. It's going to happen. I'm going to have to follow and find him again. Hello, Linda Applegate. Welcome. Hello, Salty Buddha. I'm so happy you made it. Hi, Cindy Howell. Thank you for coming. All right, guys, we are going to go. Oh, yeah, Billy always does, and he scared the bejesus out of me earlier. I opened the door to toss something outside, and a cat like ran from my yard into the middle of the road and just sat there, and it had the same color scheme and stuff as Billy, and I was terrified. I come inside, I'm like, Billy, Billy. He came running right up to me, and I'm like, oh my God, thank you. Don't ever scare me like that again. All right, guys. This is fun. Okay, I put little commentary notes on this. For one, I wasn't sure how I was gonna feel, if I was gonna be able to stream or not. So my thought was, if I had to run it as just a video without me on, I could. But one of the things you have to know is the woman in gold. This court doesn't do Zoom often for defendants. So it's not set up entirely right, and the court cannot hear her. But we can hear her. She thinks she's muted. She's not. But Judge Stevens can't hear her. So this is fun. It takes a little while. But it builds up. Trust me.
Elijah John Savoy. Is that your?
Well, I think I'm off of it now.
Printed on the docket. There's no MTR.
There's no MTRP or anything. And
It's just judicial review.
Okay.
I think it's a judicial review.
Okay, then you don't need to be
Excuse
here.
myself.
Come forward. You're Mr. Savoy,
Yes, sir.
and Ms. Valier is here. Your probation officer. You have been placed on probation since 2022 for the third-degree felony of injury to an elderly person. So you were placed on 10 years deferred or unadjudicated probation. Also, there was restitution, I believe, that was to be ordered in the amount of $14,374.19. So it's been 2 years. Where are we on progress?
Well, since he's been on probation. he
Oh,
went
boy,
on
I know the lady. Just like my sister. I can tell this isn't going to end up good. Go ahead.
We don't pay $462 since it's been on probation.
Over here. Your attention is focused right here to me, not over there. Are you kidding me?
He's autistic. I'm his mother.
Okay, come on out. Come on out. All right. Most people, many people have mental illness when they come before this court. Because most of the acts that are committed defy logic and aren't typical of somebody who's stable. But this man has not been declared incompetent. This man has not been declared insane. And he may have a mental illness, a problem, but there is nothing that should prevent him from completing the requirements in this case. And he'll be held to the same standards. No one raised competency. No one raised insanity. And that was an opportunity to be done at the right time. Whoever the attorney was, if they didn't do that, that would have been a problem. But even the state had a duty to tell me if there was a problem that would prevent him from being able to follow the requirements of probation and thoroughly resolve this case. So the fact that he's imperfect, like all of us, is not a problem with me. It's just, you got a bar set and you're going to have to get over it, which means you're going to have to follow these requirements and get them done. And I know a lot of people who have severe disabilities who are able to work. And we're talking about the paying the loss back.
May I say something?
And hold on, and what other, what other, we got, how much has been paid here in 2 years? $422. You receive a disability check of $943 monthly? Right? Can you speak? Oh,
He does it now. I'm the one that handles his finances.
okay. I don't remember, of course, we have 5,000 cases at any given time. I don't remember, and I'm really good. I don't remember you being here when we disposed of this case, but were you here when he was going through the plea and everything?
No, because
Why not? If there was a,
wasn't told anything.
when I speak, you stop,
Yes, sir.
because when we can't both speak over each other because she has to take everything down as a court reporter and she's unable to one or more than one person speaking at one time. If this is such a problem, why weren't you here then? If we're having an issue, why are you here now? Why weren't you here at the disposition of the case to bring up anything that would have affected his ability to perform on probation? Where were you?
I was at my house
All right,
because I didn't know anything about.
you didn't know anything about it?
No, sir.
Okay. Well, you didn't know he had been indicted for injury to an elderly person back in that was August of 22. This says this occurred on July 14th of 2021 involving somebody named Gordon Simmons. Do you know who that is?
I do not know him personally, but I do know that I believe he's probably 74, 75 years old. He's a sex offender. I was working at 7-Eleven.
Wait a second.
Yes, he is.
Well,
He's a sex
well, hold on. So if he's victimized, the fact that he is a sex offender, then he's not to be protected under the law like everybody else?
I didn't say that.
It's what you inferred.
No.
You know, why don't you, I've heard enough for you. I know where you're headed. I know where you're headed. We're not talking about the complainant. That should have been brought up at that time if that was so important to you, but it wasn't. Now, right now, I want to know why he's not following my probation terms. Why?
Well, when he reports, he comes in, he reports, he pays $20 on his fees. He been paying that since.
Shame on you.
And for the past 2 months, he had actually paid $40 on his fees. Each like August and this month.
Okay. Are you physically able to work?
No, sir.
What are you unable to do physically? Are you able, but I mean, are you able to lift things and walk?
Yes, sir.
Okay, well, that's what I mean, physically. I mean, you can like carry a box from here to there and things like that, right?
Yes, sir.
All right, you're not physically disabled. You don't drive a car, do you? Okay. Do you walk? Are you able to walk?
Yes, sir.
Are you able to run?
Yes, sir.
Are you able to climb stairs? Go ahead. What else? What are we doing about helping him? I know we have a program to help people get employed who, have trouble getting employment because they got to be able, we're trying to make people as independent as possible under their circumstances. So what is it we can do to help him? Because this is a lot of money that needs to get paid back. And this is hopeless at this rate. Do you live alone?
Alone.
Your mom? Who else lives in the house?
It's just us.
All right. Okay. Well, if you're going to live with her, the right thing to do is be as independent as you can and then help pay some of the costs too, since you're living there, right? As an adult. That's what you want to do. That's what we want you to do, is to be as independent as possible. How far did you go in school?
I finished.
Did you finish?
Yes, sir.
You have a high school equivalency?
Yes, sir.
Okay.
He graduated from Long Beach, Texas, but he graduated 2 years early because of his disability.
Nonetheless, he has the ability. I'm expecting better than this. You need to show some improvement on at least searching for opportunities and working with the probation office to try to get an income that can pay this back in a lifetime, because at this rate, even if you paid $100 a month, we're talking about 143 months. That's a long time, 10 years.
I'll do that.
It's not your obligation, but if that's what you want to do, that's fine. I can't stop you from doing that. But what I want is Mr. Savoy to become as independent and as successful and to achieve as much as he's able to achieve under his circumstances in life. Not to just fester, but to be productive and successful. That's probably, I'm sure that's what you want too.
Yes, I do, because I take him to spinal talk all the time.
Yes, ma'am.
He goes to spinal talk a lot. And his other probation officers, when he was first put on probation 2 years ago, it was a Hispanic lady. I believe her name was Maria. She's the one that explained to me that I only had to pay $10 to $20 a month.
Well,
for him. So that's why I was paying.
well, it's a
him.
nominal amount, but you pay what you can, but at that rate, I mean, it'll be lifetimes to pay the complainant back, the injured party, which is, we want everybody to
on the
be
important
placed
call.
back
You
in the
have to
position
wait,
they were in
okay?
as best as possible, fix the problem, and then everybody move on and be the best they can be. That's what we want.
Well, the doctor doesn't want him doing community service either because of all the people. Because he hears voices and all of that stuff. So,
Was he taking medication for that?
yes, sir, he is.
Okay. Once again, nobody brought up a competency issue or an insanity issue, which are issues that are the levels in determining where he is capable of functioning normal. And I haven't heard anything about it. And until then, the law says you're presumed able to do things. You're presumed unless it's shown otherwise. And this was the time to have brought it up, but nobody did.
I didn't know when to come.
Nonetheless, his attorney was a competent lawyer and handled this. But we need these people, two things: you to perform as best you can be and progress as much as you can under your circumstances, and for the people to be paid back for the loss. How that is done, I'm not the one fashioning the answer to it. Y'all have to figure it out like every probationer does.
Well, I've tried talking to his probation officer here.
This lady?
Yes, this lady
Mhm.
here. This is my first time seeing her and meeting her in person, because when she became his probation officer, I did have a long conversation with her, talked to her, and she seemed like she was real understanding and.
She is.
And, okay, well, when I talked to her the second time over the phone, she was very rude, hanging up in my face and all that. No.
Well, look, you, in all fairness to you, you were a little abrupt today.
No, sir.
Yeah, I disagree. See, it's, I guess, a perception issue, but at the end of the day, the court makes the determinations, and
Yes.
I'm not known to be.
Yeah, I would like
unfair.
to, if I may, I would like to affirm for the record that I've been reviewing the file as well as the PSI that was done on this matter. There's nothing that indicates about this issue. It's not something that was noted whenever the officer read this man his Miranda warnings and provided his waiver and then admission to the particular offense that he's pled guilty to. More pointedly is that when he was given an opportunity to detail that.
Who's he?
This
The
defendant,
defendant.
whenever he did his PSI and was given history, he didn't provide any of the history that we're hearing today.
But was he in a position to do that?
That I can't speak to, but I'm just
Appreciate,
saying.
understand what he was supposed to do, but
Before
at
this
the end of
moment.
the day, see, what is your name, ma'am?
Her name is Stacy Cheek.
Ms. G, at the end of the day, the man has a high school equivalency education. Unless they just gave that away, that has a level of achievement where he is competent to understand, appreciate. He knows basic subject matters and functions. No one said he was incompetent. No one claimed that he was mentally ill. See, so these are things that, if they're valid, should have been brought up a long time ago. I mean, it's like the train's been crossing the country, and now from San Francisco to Miami, as we're approaching Miami, then go, you know what? The train shouldn't have left in San Francisco. We're turning around. That's not the way it works. That's why the process is built up to deal with these along the way. But unless they're giving away high school educations, just giving it away, he would have had to have made an achievement, unless you're going to allege that those people were incompetent in their jobs.
Well, him and some other kids.
Ma'am?
Him and his other kids, they only had like 4 or 5 other kids in his class. It was a very
what?
small class.
Well, that's
For special
the recipe for higher learning.
for special ed.
Anyway,
And the officer that did arrest him knew that
Yes, sir.
he was a Spinal patient.
okay. Does he live with you?
Yes. he
Okay,
always has.
he's always lived with you.
Yes, always.
And, but I don't remember you being up here on these hearings at all.
No one has called my phone.
Well, you didn't know that the person who
knew he
lived in
was-
your home, your son that you're saying is not as independent as he purports to be in the file that I'm looking at,
I knew.
needed your kind of assistance? You didn't, I mean, we have a process from an initial appearance, an arraignment, hearings, then a plea hearing, then a sentencing hearing, and you never
No, sir.
bobbed up?
No, sir, because I didn't know anything because he got arrested on the 31st of July.
Was he in custody that whole time?
Yes, sir.
Mhm.
He didn't get out until right before his
But-
birthday in November.
But I mean, but all of these are public records. I mean, you never inquired if you needed to be here. You never inquired, when is he going to be in court next? When is he set for court? Because
I called.
my staff, somebody would have told you it's a public record, and you would have been able to pull dockets and look him up.
On a positive note,
All right.
Judge,
Yeah.
the probation officer points out that he was on what's labeled as the MHI caseload, which is the mental health initiative caseload. And he completed that and has moved forward to the mental health caseload, which he's been on since June of 2024. So.
Which means what?
Means
What
that
difference is that?
Well, the difference.
Probation.
Forensic program, they are more hands-on with them. Go to the doctor's appointments.
Is that right, sir?
I think it was.
Are you feeling better about, are you doing better now?
Yes, sir.
Good.
So
Okay.
my point was, we're doing what we can from our side, Judge.
And again, on restitution, you pay what you can under the circumstance. And that's all the law requires. But what we want really is for all people to achieve the best they can be under their circumstances. Okay. So whatever that is, under his circumstances, what do we need to do now? Anything else to help him move forward? Yours, Mom, what else can the probation office do to help him?
It's whatever, like she had asked me, she talked to me about him doing his anger management on my laptop. I paid for that. He did it. But I did have to assist him with the help
Okay.
on the laptop
Okay.
because he's not computer,
Literate.
Yes, sir. So I had to help him with that. But like, if y'all still want him to do community service or whatever, is there anything he could do besides the public? Like, is there anything else?
Why don't y'all work that out and let me,
Community service was waived. It was waived.
there you go. There's your answer.
Is there anything else you want him to do?
No, that's all we have to do. It's just his fees.
Try to get an income to be able to pay the restitution back. I know you're saying, oh, I'll pay it, but I'd rather him meet an obligation, which is normal and customary for everybody. When we have an obligation, a debt, do we have to pay? We're required to pay it back. And I'd like to see him do it and be as responsible a person as I think he is able to be under his circumstances. Want to achieve as close to normalcy as he's able to, right? That's what
Yes,
we
sir.
all want.
Yes, sir, I do. That's what I'm trying to ask her, how much do you want me to pay? Because if I pay, which
Here's
I
what we're gonna
asking
do. I want
for,
y'all to, can you work
be
with
a
that
council.
later? And then run it by me and see, because at the end of the day, I'm the last decision maker on it and sign off on it.
Okay.
But if y'all can resolve something that is reasonable, I'm always agreeable to it.
Yes, sir.
But also whatever we can help him be the best he can be.
Okay,
And you live with him every day. We just see him part-time.
right.
So work with her on, she'll get to me on modifying any terms and conditions of probation that can help him successfully complete this.
Okay.
And he does well. We always reward people by shortening their term of probation.
Yes, sir. I got you.
You know what I'm saying? You know how.
Yes,
you know,
sir.
Yeah. We reward. Okay. That's a fact. I do it every day. Because
I
you
appreciate
can't do 5,000 people. And if they get it, they're fixed, we're on the right track, then good. We trust they'll do fine. We've
Yes,
got
sir.
others, we have fires we have to fight. And if it's not a fire, we can move on. Okay, thank you.
Thank
Let's review this though in about 3 months, just to see how he's doing. Okay,
Mhm.
please get a resetting there, sir. Thank you. Bradley Atkins,
Multiple cases.
19-33051 is called Bradley Atkins. Is that you, sir? Yes, sir. Mr. Galmore is here with you. And this is a status review. Yes, everybody, what is the status here? Oh, I've got an administrative hearing August 1st. Scheduled judicial review, which I ordered, and it says you tested positive for THC in February, March, and May for Dallas County. Continues to use drugs, unsuccessfully discharged from safety aftercare. You'll have a chance to shake your head. Yes. You have worked 0 hours, have 800 hours of community service. When you're on probation? 3 years now? Over 3 years?
Yes, sir.
No community service?
Insane.
And you'll have a chance to
I'm
speak,
sorry.
Mr. Interrupter. And as of today, you owe $6,883 and are in arrears 718. You have, according to the probation officer, you have shown less than adequate progress since your probation. You appeared in the department for a hearing to discuss and your analysis was conducted before this hearing on July, and it tested positive for THC, methadone, and synthetic marijuana. Yes, it did.
July what year?
Huh?
Year? July 23rd this year. This year?
Yeah, 2 months ago. Less than 2 months ago. While in the UA restroom, you adamantly denied any substance use. You mentioned taking a 14-panel drug test the day before that you obtained from CVS Pharmacy that were negative. Yeah. Okay. You have to understand, they don't work for me. And the panels that they use are different from what we use. You asked for a second test, a second instant test. This officer requested that the UA, urinalysis tech, conduct a second test. That second test was revealed the same results as the first test. Anyway, that your rebuttal with the CVS test has zero credibility with me. Because I know about it. Okay, Supervisor Wright advised you that you have two options, safe P relapse or an administrative hearing. You said you would rather neither, but instead wait for your analysis tests. Well, if you only had the option, if you were only the decision maker, but you're not, I am, and we stand by our tests. Okay, so the positive urinalysis for tetrahydrocannabinol, marijuana, and being unsuccessfully discharged from safe P aftercare while in Dallas County are to be addressed. And then it should be noted that during a telephone conversation with the defendant on February 29th, the defendant says, I got a CBD gummy from a person that worked for knee pain. During a telephone conversation on June 6th, you said, I took an HHC CBD energy shot. And according to the probation office, you are not being held accountable for your substance abuse, which are clear indications that you are not ready for a sober lifestyle. So we have scheduled this. That about summarizes this. All right, look, the tests are accurate enough that they are relied upon. And you can imagine how many times people deny that there must be something wrong with the test. But we're going to follow the test results and hold people accountable. Or else what we're doing here is just a gigantic waste of time and effort. 85% of the people are successful on my watch. 85%. 85%. Are you the 15% or not? That's what we're going to find out. But 85%, which is higher than the national average of 70. We're twice better because of the way the probation officers are dedicated to getting their clients, you, pulled across the finish line successfully. All right. So here we are. We've got these allegations, and I'm looking at this motion to revoke that was filed 2 years ago. You remember that one, sir? How'd you do in that? Court. Well, what did you plead true to, among other things? Number 9. You pleaded true to failing the drug test with tetrahydrocannabinol in your system in February of 2022. So you're not incapable of using tetrahydrocannabinol. Plus, you admitted to theft of property, being in a county when you weren't supposed to be, and again, testing positive for drugs. So thought we had that all resolved, and then now here we are again. What should we do? What's probation office suggest, Mr. Williams? You're going to get a chance to be heard, just like you were last time. Which here you are again, which shouldn't even be. I shouldn't see you after the first time I put you on probation, sir. Should never have to see you again, except to celebrate your completed successfully. This is the 3rd time you've been before me. Go ahead.
So as outlined in the hearing, we tried to give some options, safety relapse, or, come back before you judge for judicial review and let the court decide. So those were our options. So whatever the court decided in this matter.
What about the safety relapse program? What do you think about that? What do y'all think about that?
Well, Judge, I believe at the time I had the administrative hearing, he chose to come here for certain
I,
reasons. And
here we are.
I do have some things I'd like to address.
Go
at this
ahead.
Appropriate time. I believe the court stated earlier that he failed a drug test on July 23rd, 2024 for synthetic marijuana and opioids and methadone. But in reality, that was sent off for confirmation, and it did come back positive for marijuana and alcohol. But
Is that all that's necessary?
I'm sorry, I don't understand.
Is that all isn't that all that's necessary?
Yes, I just want to
Okay,
make sure that.
all right,
that
that's,
the
I
court
think
mentioned-
it's the same thing. It looks like a repeat performance from what happened in 22.
Mr. Atkins states that he disputed the drug test at the time. He states that he is drug free. He did take a hair follicle test at my direction. I have provided that to the state. I know that the court has stated in the past that hair follicle tests and urine tests aren't always the same standard. But he was negative on all those tests. Also, he states that he could pass a drug test today if it was important for any reason.
It was important a couple months ago.
He stated at the time.
He's supposed to pass it every day.
Right. I stated.
You can't purge it by, okay, I flunked, but I'll pass it today. That won't purge it.
Believe at the time he failed the test for marijuana, he did state that he used legal CBD products that do cause false positives on THC drug tests. He quit using those products, and I don't believe that he will have that issue anymore. I think what would be important here, though, is to increase.
Why would you do something like that? Why would you do that? If that's true, why would you do that?
Knowledge that had THC and it would cause a positive. I'd broken my phalanx bone in my foot. I declined all pain meds. Just try to find a natural approach to it.
Of course, Judge, at the time, when he was originally charged, the court did not have the additional rules and regulations related to legal marijuana because it wasn't legal at the time. Of course, now the court has bond conditions related to those, but at the time, that's not ever addressed, in my opinion, in my knowledge with him. It's a new recent development since he was originally put on probation.
Okay. Full-time jobs.
All right, what else?
Well, Judge, he does have a very good job.
Yeah, there's a lot to lose. That's
he
why,
is-
why would you flirt with trouble?
He does have a lot to lose. He has a lot more to lose than probably a lot of my clients. What we're asking the court to do is consider some additional safeguards for drug use. I've discussed with him the drug patch. He's willing to do whatever the court orders him to do. He would like the opportunity to not lose his job. And he's living and working in Dallas, reporting in Dallas. But if the court wants to see him regularly to make sure he is in full compliance with whatever additional measures the court, he will do that. He can travel here today. He can travel here anytime.
It wasn't us, it was Dallas County that did the test, right?
Yes, sir. And with them unsuccessfully discharging him from safety, they sent his case back. So yeah.
I've known as my fiance, who's a physician in Dallas, at the Collin County. And she's a huge support system for me. So if you would please, let me transfer there.
Look,
I'll redo
look.
the program, the aftercare program.
What's fair for one is fair for everybody. It's not unusual for people to try to explain away a positive test. We're either going to follow the scientific method or not. If I don't, I open the door for one, I open it for everybody who comes in with a similar excuse. They'll go, I want the Bradley Atkins. I'll use the Bradley Atkins story, please. I have to let everybody through. That's what's fair, sir. But you're not admitting to it, but you're admitting to using CBD products. That's you're flirting with trouble there. You don't have to do that. Why would you even get near that? With what can bleed over? And besides, you don't know what's in those, really, at the end of the day.
Correct.
All right. But that's you're putting yourself in vulnerability. That's your choice. I think a reasonable person would just go, I don't even know what's in that stuff. So I'm not gonna get it. I'm not gonna get near it. But there you are, and here you are. And we're gonna follow the scientific method. I'm gonna believe in science rather than a story that really, for a smart guy, you could have done better on a story. Why would you get around this stuff? All right,
So can I please use the drug patch?
sir.
Can you please drug patch?
Oh, I'll probably put you on a drug patch, but that still doesn't purge the mistake you made.
Judge,
Yes, sir. What do you have to say? Go ahead.
I'm tired of looking at Mr. Atkins, to be honest with you,
Well,
Judge.
That's.
This is,
That's not
and
the test.
I understand, but I start that because I want to remind Your Honor where this starts. The story starts in 2019 with this offense where he breaks in and he steals his grandmother's pain medication. That's the burglary of a habitation. There were actually 2 charges because he didn't just stop with her. He did the next door neighbor at the senior citizen living place that this had. This man has had a problem since 2019. Reluctantly, I dropped one of the charges and agreed to place him on probation because I was convinced then by his defense counsel that he was going to get help, he was going to be a changed man, and we weren't going to see him again. In 2022, when he came back in here because he had continued to do the same kind of conduct and he was caught inside of a hardware store, supposedly under the influence again, stealing, those excuses were offered. And Your Honor heard a hearing. He entered pleas as far as that was concerned. And we decided that the best thing to do was to get his attention and send him off to safety. Now we're sitting here listening to more excuses.
Hold on. There was also 90 days in jail.
Yes, Your Honor, I apologize. I'm trying to be brief.
But I understand, but the point is, you couldn't have enjoyed 90 days in jail.
Your Honor, I will always back you with whatever decision you make, but I'm telling you, my own personal opinion is that Mr. Atkins has used up every excuse that he can. It's time for him to go to prison.
Well, if it is, you're looking at up to 20 years in prison. You understand?
Judge, it may not change anything.
Yeah, go ahead.
It's not relative to what we were just talking about, but it was brought up that Mr. Atkins was behind his money. And it's my understanding he has paid off.
That's the least of it.
Sure,
That's
I
the
just
least of
wanted
it.
to make sure it was,
I mean, it doesn't do any good to be
just want to make sure it was known.
intoxicated, but paying back. I mean, that's not, it's well-being of all parties, including the defendant. That's what this court wants. And, okay, what other options do we have other than this, which isn't a bad idea? What are the options from probation that we can use here?
Just as mentioned before, we can do the drug patch.
More.
Relapse.
Safety relapse.
What does that
I mean,
entail?
so basically he'll go back through the same program as
How long
safety,
is
but
that
it'll be a
program?
little bit more intense.
How long is that program?
That program is 6 months.
Right. I wish you wouldn't have tested positive, so don't be shaking your head.
Judge,
20 years, you're looking at 20 years in prison, which I can do here. It would take him 20 seconds. We're trying to give you all the opportunity to help yourself, it's like we're trying to help you and here's some money, go do the right thing. Okay, I'll buy a stick of dynamite, light it and put it in my shorts. That's what's happening.
Judge, I would like to point out that he did finish the SafeP program.
What other programs do we have?
That would be that would probably, at this point right now, Judge, that would probably be the best option as far as the safety relapse. He was unsuccessfully discharged from the aftercare program due to his substance use.
Yeah, that's that transition spot when they finish the SafeP program.
That's bad. That's the thing that stings here.
However, the inpatient portion, the longest portion, was successfully completed. It was the last month of the outpatient program that was not completed successfully. It seems like another outpatient program, if it was successfully completed, it would not be necessary for the court to use inpatient resources.
Okay. I understand. Just had the Olympics. You run the mile. You set a world record. You're ahead of everybody by 100 yards. At the finish line, you stumble, fall, and you don't get up. What do you get? Participation medal? Not even that. Doesn't matter, 99% of the time you were ahead. You got to complete it successfully. That's like everybody does. Anyway, we're taking too much time. This is enough. What I want to do is, I'm going to look at this. I'm going to come back in a week on this and see if there are any other alternatives other than this other method. But you're going to be on a drug patch immediately as a modified condition. But there's going to be some other programs that we're going to add to it. And you're beginning to get too busy on this. This is all problems. And what's worse, you got my attention, which you don't want. But this is your choices. So I'm going to reset this 1 week. Okay, here and deal with it. Everybody will have a chance and we'll see what my options are and how that plays out. Sarah Burnett, David.
Yes, Your Honor.
I have 2 cases here. 13-17581 felony theft. You are on probation for, and then 15-21605 another theft. You are on probation for, and you were required to pay 10 years ago $131,000 in restitution and $10,000 in restitution in each of these cases respectively. So I guess this is a review on where are we on things and where are we?
Yeah, not federal.
Okay. All right. From the last, when was the last hearing? We had a motion to revoke probation filed last year, correct? In one case. And in both cases. And those have been pending. There were no pleas to them. How much has been paid back, which is what this is all about? It's really not all about that. Let's see. She tested positive for THC. Okay. On 8/27.
That was also a CBD.
Yeah. Oh,
Well, I
were you
mean,
with him in the same
no,
car,
sir,
the last guy?
No, okay.
Well, that was a good, boy, I'm learning something here by being in court early. Yeah, that's a good way to go. No, the CBD excuses aren't going to fly with me. God bless you. I've never thought, I mean, we went through law school, we never saw using gummy bears as an excuse was a legal defense. Never read that, but there it is. Okay. How much was paid back in the last year? That's what I wanted, among other things. How much would you say?
This year.
Yes, ma'am.
She has paid a total of.
When you say this year, since January?
Yes.
Okay.
$852.
To this point in time?
So there were 2 payments made, one in April and then one last month, one for 502 and then one for 352.
Okay, so the total through,
852.
okay. That's about $3 a day toward the loss here. And what's the balance owed in each of these cases?
For the 581, the total balance is $134,186.26. And then the one in the 5.
Wait, hold on. The balance is how much?
$34,186.
Okay, I'm just going to ask about restitution. How much is restitution owed in that? Okay. So in 10 years, we hadn't paid but about $5,000.
2 years rest.
toward restitution. Okay, and what about in 21605?
All mine went toward restitution.
Okay, how much is restitution owed in that case?
That's the amount. The 10,596 is the balance. What she has paid is 275.
Wait, 10,900, but the restitution that was ordered was $10,971.
The amount that she has as a balance is 10,500.
500, so she's paid 400 on that. Okay. And that's over a decade, right? Well, that's not long, but testing positive for THC, huh? Okay. All right, what, anything, David, you want to add on this?
No, Your Honor, she's been on probation for such a long period of time. I think that she will tell you that she paid what she could, and she's had some problems. Not just problems in pain, but she's had some problems, some other problems. That not to say that they justify not payment, but there have been some other things that have occurred.
So what's they say?
Well, I mean, she still owes a large amount of restitution, Your Honor.
Here's what I'm going to do is this. I'm going to ask the state to amend these motions to include the THC. And we're going to have a hearing on this, and we're going to resolve it. It'll be resolved one way or the other at that hearing. Get ready, because you're looking at 10 years in 14, and the Senate's, I can't read that. What was the Senate's in 2165? Was it deferred? Okay. So and that's a state jail felony. So you're looking at up to 2 years in that. But time is run out on that after a decade. We're going to move forward. Okay. So I'm going to ask for the motion. We'll come back and then we'll have a hearing on it. And then I'll make my decision.
Right.
That is,
I'm sorry, Judge, I missed it. Did the court schedule a date for the hearing?
we're going to have to get with her. Yeah. But there's a motion to be filed in that one case.
Well, it's not
it's going to be amended to include the THC. Does it have THC in it?
They did the amending administrative hearing has already been sent to the DA's office to have the amended.
Oh, okay. It hadn't been completed yet. We don't have it yet. So, but now,
We should have it.
but everybody get ready, because you're looking at 10 years in prison in one case, 2 years in the other, and we're going to move forward in one way or the other. That was all. Ardeshore Jimerson, please. All right. Are you Ardeshore Jimerson?
Yes, sir.
Present with Mr. Grove, your attorney and the state's attorney. What we have here is a fourth amended motion to revoke unadjudicated probation, which I don't think I've seen in 17 years. But it last alleges that, among other things, the fourth amended included utilizing something to fake a specimen here, providing a urine sample in the third amended that showed drugs. Second amended showed possession of unlawful substance and tetrahydrocannabinol. First, and then it was initially alleged in each case that you didn't perform community service hours or complete anger management program. Well, now we got drug issues popping up. So what are we going to do today? Is this a hearing? Ready? Are y'all ready for a hearing or what? Because
I think it's just a review of safety aftercare, Judge.
Yes, sir. I believe that's correct, Judge.
when did we send him safety?
According to my notes, July 26th of 23. He had entered a plea of true to count 6, 7, and 8, and you ordered that he go to safety.
6, 7, and 8 of what? The fourth amended motion?
I'm
Yes,
looking at
sir.
Mr. Laird's notes, Judge, and it doesn't indicate which version. It just says count 6, 7, and 8.
I believe that's true, Judge. We had a little bit of a problem with some numbering somewhere in here, but I believe.
Well, what I
That's
have
correct.
here is something that is not, I have a copy of a fourth amended motion that doesn't have a file stamp on it in each case. And also has a misnumbering on the final allegation of violations is a misnumber on each case. It goes from 7 before it to 5. And 6 before it to 5 in the other case. So there was a mistake, and I kind of remember making changes on that, but I don't have any of that. I don't know what happened to those original.
Judge, I have my handwritten copy.
Here, I've got it.
making
Hold
those
on,
things,
hold on.
But I don't have a copy of the thing.
I found one, but I don't find two. I found one.
Mike's notes do reflect that that was done in cause number 24480, Judge, if that assists.
Yeah. I have that original, and it was file stamped 7/25/23, and I did make. He pleaded true to allegation 6 and 7, and I had to change, add on or about a date for the fourth amended number 7, and I had to change that 7 from a 5 to a 7. All those changes were made. We did that July 26th of last year. So since then, what's happened?
He was discharged successfully from safety,
Okay.
residential safety, and he has entered the safety outpatient aftercare.
Okay.
He's only tested positive once for THC in July. He was sanctioned by us, but
Only once is only once too many.
Yeah.
Are you kidding me?
I told him about it, and so that I had to let the court know that he had a review hearing.
How much time has he had? Upfront time. So we're doing it upfront time. You're gonna go to jail. Every time you commit a crime, you're gonna go to jail. On my watch. Do you understand?
Yes, sir.
My goodness. You're gonna do 10 days in jail, sir. As a condition of probation for that. And it'll keep going up each time I get a scintilla of drugs in your system. But that's the problem from the beginning. You're looking at life imprisonment on this case, aren't you? Aren't you? In the aggravated robbery?
That's correct, Judge.
You're looking at the life imprisonment, and what that is all that it takes. I could revoke your probation and find you guilty and sentence you to life in prison for that. You want to flirt with that? Yes, you do. You did it. Then there's a burglary adaptation. That's up to 10 years in prison. Yeah. No. No, every time you commit a crime, which is what you did on my watch, you're gonna go to jail. You're gonna go somewhere because you've had more than your fair chance in 2016. Okay? All right? You understand? What else are you doing to help yourself?
I have to do sanctions of NA meetings. Then I also been doing my classes.
Well, how did this marijuana pop up? Were you with the CBD group? Were you eating gummy bears with the other two?
No, sir. I'm on color code.
I know.
2 days after I did it, I asked him, could I take another one? But apparently
See-
my color code called me 2 days later, and I was negative for it. It was like I must have been
Okay.
around it, and it went through my system. I must have just been around it. I wouldn't.
Well, you know if you're around it or not.
Yes, sir.
It has a distinct odor. But you're gonna do 10 days as a condition of probation here. Do you understand? Where are you working?
Right now I work for lawn service company.
Okay. You want to do weekends on that, or do you work on weekends?
Only some weekends. It's like
Which one do you want to do 10 days in a row or weekends? Which would be 3 weekends or five weekends, rather.
It'll be long if you do the weekends.
You only get two days credit on weekends.
So if he does the 10 days straight because he's in the safety aftercare, it's gonna automatically boot him out that system. And it'll unsuccessfully discharge him from the aftercare.
Where is he in this, in the aftercare?
At HR in Port Arthur.
No, where is he in the progress of it?
He's at 90 days right now,
All right.
and
What does he have to have?
he has to have 9 months. So if he misses 3 consecutive groups or 3 consecutive individual meetings.
All right.
Dismisses.
All right. When this is over with, you're gonna have to do 10 days in jail. Unless I change my mind. Oh, you understand?
Yes, sir.
All right. But don't let this happen again. Or else all that time that you've accrued, you will have lost it on this aftercare program. Because I want to see it. I want to see if it's successful, but that's not the way to do it, by testing positive. Do you understand? Even if it's marijuana, everybody plays that down. Nobody really knows what's in the marijuana. That's the problem nowadays. It's being clandestine labs, it's being mixed up with all kinds of bad stuff. Unless you're mixing it up and you know what's in it.
No, sir.
Okay. All right. What do we want to do? Review and win.
I'll get started about 3 more months.
Got it. I'm gonna reset it for 3 months, okay?
Done with the aftercare then?
No, he's,
Okay.
yeah. Hopefully, no, he still has 6 more months at
Yes,
aftercare.
sir.
LaKendra Wallace. Where's Kimler today? Miss Wallace, have you seen your attorney?
Oh, so he
Do you know where he is by any chance?
said he was in orange when he said we had to do something.
Yeah, well, he didn't alert us. I'm sorry. We're gonna see him wait on him.
Here, so I'll make sure it's Lacey or Ellie.
Kimler's not here. That's the attorney. Is she?
Oh, ask your sister.
A
Anything you need.
different person was here.
I think
Yesterday.
I think it was Lacey, but I know he had a competency hearing. They want to move his like mine for this morning. So he wasn't
A
available.
competency hearing for Rife Kimler?
Yeah.
That was long overdue.
But he had a individual yesterday that we both had in the box yesterday. He sent us a note.
Facetiously, we're talking, we're all, that's Jim.
But they tried to remove his both bars to this morning, and he said he wasn't available this morning, so they were only fine. So I know
Okay.
they let somebody know yesterday.
Well, who's the probation officer on this one? On Miss Wallace? Mr. Wallace, come on up.
You got to be decent. Okay. I'm waiting on them to call my name.
Well, how we doing?
Not good, Your Honor.
Oh, darn. Okay.
Well, last time she was in court, she was reviewed for 6 months. She reported to me last in April, and I haven't seen her since April. So there was another second amended sent over before it fell to report.
I don't have it.
I've got it. It's been signed, but I don't think there's a motion.
Sorry. Okay, you haven't, has a motion been filed on?
Not as of this morning.
You should have it.
Okay.
Nicole,
You have to
I'm
report.
sleeping.
If you can't do anything else, report. You have to report or else you're not on probation. Okay, I'm gonna reset this, get that through.
Yes.
Reset it for next week, please. Get a resetting.
Just the
Your lawyer
nuggets.
can be here. But
I know.
this isn't good.
She been up since like 3 or 4.
If you can't do anything
She went
else,
to
you
sleep
have to
so
report or
early.
else you're on your own probation, which is not my rule. I'm ordering you to report. If you don't report, we can't help you. All right. Ricky Rodriguez. John?
Yes, sir. Stand here and ready.
Ricky Rodriguez. There is no answer in the courtroom. I asked the bailiff to call into the hall for Ricky Rodriguez.
Okay.
Come on up. Don't be shy.
All right, thank you.
What are we doing today?
I think you already was still in advance. Last time I think you're just checking status to make sure.
Yeah, but I didn't.
That's what I had on mine. I'm sorry.
There's a motion, but we never pleaded to it or anything.
That's correct.
Something needs to be, we gotta it's time to move forward on it one way or the other. And then if we're gonna hold an abeyance, then we will. But I mean, but it has to be pleaded to.
I'm not sure, Your Honor. I just going off my notes.
My notes reflect he had a court date back in January that he didn't appear on. This is the next setting, Jeff. So he has not entered a plea to a motion to revoke probation.
What are we going to do?
I'm not sure, Your Honor. Like I said, I'm
It's
just going by the notes.
It's a rearage. You have you seen it? The motion?
Yes, Your Honor.
Okay, arrearages and it's all about a money thing.
Yes, that's
But
what I thought.
let's see. October
I
21st.
apologize, Judge. There's a February 7th date where we established how much the restitution was, and we ordered $700 a month and a review in 3 months.
I'm going crazy here. All right. Oh, that's what we did.
How much has payment been made?
He's been making payments every month. He makes approximately $900 payments. He owes $1,779 left in restitution.
How much?
$1,779 with 20 cents.
What he had for restitution?
Yes.
He had 38,000 at one time.
Right.
He's paid that?
Yes, yes.
Well, I'm not
It's
going to
been-
disrupt that.
Oh, yeah, that's what I was asking, just to keep them going and keep it going. You just
Okay,
wanted to have a review. So.
Another 3 months?
Yeah.
Okay, reset for 3 months, sir. Thank you. Keep up the good work.
Keep doing good. Okay. Okay.
$38,000 in restitution, and he's only got a little over 1,000 left to pay. Wow. He's one of the very few who actually did it, like made an effort, worked hard, and took care of it. Kudos on him.
Well, I like those. Roland
It's okay. I
Wilkinson.
was like, wait a minute.
Roland Wilkinson.
Matt, the event's calling out when you're on.
Yeah.
I'm not seeing him.
2 cases are called. Dennis, 22-39212 and 39507, the state of Texas versus Roland Matthew Wilkinson. There is no answer to that name being called here in the courtroom. I ask the bailiff to call into the hall for Roland Wilkinson, please.
2 hours.
No response to that name being called in the hall. No response to the name being called here. Mr. Wilkinson has failed to appear. And what is his, when, is he an absconder?
Yes, sir.
Since when? I have this, he pleaded true in November of last year for being an absconder or failing to report to the probation office during 2023. What, and what did we do on that?
Your Honor, you held it in abeyance. You continued his probation. You set him up for a review every 90 days. But Judge, that's the last time we've seen him.
Yes, he did report in December and January of December 2023, January 2024. He was scheduled to report in February. He called and stated he was running late and never called me back. And I've tried to reach him by phone, text, and email and his references and have not been successful in finding him.
Then I'm going to request an amended motion to revoke probation. Can you send me a memo on that? Will
Do you want a memo or just another hearing within the finding?
whatever's the easiest way to get it done, because when he's failing to appear, that's really not an issue, a controversial issue. I just need something to move forward with an amended motion to revoke unadjudicated probation, taking into account what has been added to what was alleged in the motion to revoke probation of August of last year.
Yes, sir.
And then we'll be able to, we'll find him and then we'll take all that up at one time. Taylon Williams. Taylon Williams, please. There's no answer. 18-30293 to Taylon Williams. I asked the bailiff to call into the hall for Taylon Williams. Is this one going to be gone?
I don't know, Your Honor.
Oh,
No,
is that her?
She's always here. Let's say she's never missed a meeting or a court date. Hers was, I think, restitution as well. I think she's.
Okay, we have a motion to revoke probation that has been pending. Restitution was almost $8,000 back in 2018. I'm anxious to know where we are here. The last thing I see is a motion to revoke probation filed in March of 2022. At that time, well, there were a lot of violations here,
Yes,
but including restitution. Anyway,
You kept her on probation and she started.
probation. What's the word?
She's currently in active probation.
Inactive? Well, that's a good thing.
She's not, so she's not reporting, but she was.
She's not having to report.
Right.
Right. She was instructed to continue paying her supervision fees until they were paid in full, but she's only paid $20.
How much restitution is still left?
Restitution is paid.
Good. Okay. So how far are we behind in regular payments?
She owes a total of $2,417.
Okay. What else is she having to do?
That's it, just pay.
You've been on probation over 5 years now, right?
Yes, sir.
So this motion has been pending, and that's what holds this. Otherwise, you would have been released from probation. It all would have been well.
Yes, sir.
And how much is she behind? I mean, what's the amount?
$2,417.
If that could be paid, is there any other thing holding her up? Then the case would be dismissed.
Yes, sir. Yes.
Are you able to do that?
Yes, now that I'm working, I wasn't working for a couple of months.
Okay.
So
Can we, is there, she's inactive, that's freezing the costs though, right? That
Yeah.
she's not,
There's no added fees.
so, but the longer, if you get in trouble, if you commit a crime or something next week, this motion's still there. So you haven't been released, then you'd have to be answerable to me, which you don't want. The money thing is required, and that's the only thing keeping you from this case being dismissed. When do you think you can pay that? Because it's not increasing. It's stable. 2,400?
It's up to
I know that's a lot of money to me.
Oh, it's still a lot of money.
But
Yes.
that's the difference between you having this case pending and you're a free lady.
I'm not really sure on when, but I mean, I can make payments on it, not from break.
Can we maybe reset for 3 months and see? what
Yeah,
stands?
yeah. Whatever it takes to get you across the finish line, you're this close.
You're right there.
Okay.
I think we said about 3 months.
Let's review it in 3 months. Okay, thanks. Good luck. Otherwise, don't get in any trouble. So, okay, just do what you're doing. It's the right thing. Jeremy Cameron. Oh, it's been a couple of years here. There was a third amended motion to revoke probation that was filed that he pleaded true to back in 2022. So here we are in 2024, over 2 years. And it's been on probation since 2018, 10 years deferred. But there's been 3 motions to revoke probation filed. Actually 4.
Actually 4. Yes.
And but the last thing I have is this administrative matter, November 2022. I guess this is a review we have every so often of how's he doing? And that's my question.
He went to ISF, he successfully completed ISF. Since being released from ISF, he was placed back on a mental health caseload. I think that's the biggest thing. He hasn't been making his mental health appointments.
Why not? Well, are you calling to say I can't get there because I don't have transportation?
Yes, I recently just signed back up to start.
Okay, well, you can't miss those, or so you're not gonna miss those anymore,
Yes,
right?
yes.
Because you don't wanna go. This is a 3rd-degree felony. That's up to 10 years in prison. We don't want that, right?
Yes.
Make sure they cook, cause I had
What does he
them
have to
sausage links in there and they got oil or grease. I had to cook our nuggets a little bit longer so that grease wouldn't be on them nuggets.
That's the only thing he has to do.
Was there any of that restitution?
No, he don't have any restitution.
Well, it sounds like he's really hardly paid anything.
Since he been out of ISF.
I hate going after motherfuckers that ain't doing what they supposed to be doing.
How much Do you make it out?
Like bad case after bad case. Besides
How
maybe
many-
2 of them.
Did you talk to him, the lady, about how much you can make? How much you can pay toward this? 'Cause
I've
you gotta
literally been
help
on this
yourself.
fucking
How
thing
much, you think?
since 8:40.
Y'all are working at, yeah, don't stretch. Because
No, they're
we'll
an
hold you
hour
to
ahead
it,
of us.
but y'all need to work that
Oh,
out.
it's was 7.
Okay, I don't see any reason we need to spend much time on this one. It sounds like something y'all are able to work out. If not, bring it back up to me. But there's some way you can whittle those things down if you're not committing any crimes or otherwise fouling up. You know, we can shorten probation terms in 1/3, and you've already passed that up. So you're eligible for early termination of probation if you can get everything else caught up.
Yes.
Okay, let me review it in 6 months. Thank you. George Collins? Okay, how we doing, Mr. Perry?
Here, I sent a memo to the board.
On August 15th?
Yes.
I couldn't even make my $100 payment today because of the fucking had to pay the energy bill. I'm like, oh my god.
Spicy misdemeanor.
I pay $100 a month on this
24,
fucking shit, and I ain't paid since June.
Right?
And I ain't got time to be in his mouth.
Reduced.
I asked your daddy this morning. I said, I don't know, I got my PO thing. Then I still paid 100. Oh, I don't know, but that energy. I'm about to go back to work. I'm like, I'm just so annoyed ever since yesterday. I've been knowing I had the court date since last month before when they rescheduled it.
In fact, what are you asking for here?
Directives for the court, he's under medical, under Compassionate Care Use Act, medical marijuana, and your directives of that have GPS.
Both my AirPods and went dead.
Yeah, I'm changing.
I keep switching them out. I'm like,
What you're doing, if you're gonna do medical marijuana,
I don't
you're
know.
giving us
You
your
never know how
driver's
many on the
license,
docket, but I
'cause
see
you're
how
not
many
gonna drive
people
a
on
vehicle.
YouTube watching this shit
And
live.
that's the way
And I'm
it is.
sitting there at the bottom of the
You wanna do
screen.
it, fine, but you're not.
Just
gonna be
looking. That's why
operating
I'm just
a
like,
vehicle.
whatever. Just hurry to get this
And
shit over with.
There's
I'm
not
just-
much we can
whatever.
really do if we don't have your driver's license. If you get caught driving a vehicle, then that's your problem. But you're gonna have to get another ID card, but you will not operate a motor vehicle while you are taking medical tetrahydrocannabinol. You understand? That's my order.
I say something.
Yeah.
I really don't have a support system to drive me to and from.
That's your problem. You make the choice on the
Okay,
medical.
and
You made the choice, but what I'm going to do is you are going to surrender your driver's license to the probation office. And we're going to have it. You get an ID, but that's that's the only thing we can really do to prevent you from getting in a car. But people are figuring a way, well, they'll just use this medical marijuana. That's fine. There are other things you can do in lieu of having to take drugs. But if you're going to do that, you're not on my watch going to be operating a 4,000-pound missile. So that's your choice. You make the choice. If you're going to do this, that's fine. I'll comply with this. Your order is you surrender your Texas driver's license to us. That's the order. And get an ID.
Okay, I have something else.
Sir.
I need a pass as well. I was wondering if I could transfer. I was trying to transfer.
Transfer what? No, we don't we have never transferred cases. We do courtesy supervisions. We allow courtesy, but we don't transfer. Because if you want to do a courtesy supervision, then I'll consider it. But it has to go through them first. But you get a job over there or something?
I have a job in Westlake where my son lives in Houston.
Yeah. Yeah. I want you to be able to be free to take care of family and your.
I'm sorry to interrupt it. It was presented to me yesterday evening, and I do have the employment-related child permit ready for your signature.
Okay.
Employment-related child permit. His work is outside Jefferson County, but within driving distance of Jefferson County.
Yeah, I don't have a problem.
Okay.
Whatever it takes Grim, but look, the medical marijuana thing, that's the way it is. Where are you getting it from?
Dr. Austin.
And where?
Doctor.
I have a letter right here, Your Honor.
From where?
Austin, Texas.
Austin.
I think I did attach it.
It's not a loophole, right? I don't use it. It's operating vehicle.
See, let me just tell you this letter. And this is a physician purporting to be, I don't know who this is.
I did verify with the.
But it says this letter serves as my recommendation that George Collins would benefit from the use of medical cannabis to treat their symptoms. That's not even the right usage of the English word.
It's legit. Wait, the way they write it up.
Oh, well, they're supposed to be intelligent people. I mean, this is first of all, he signs it purportedly. I guess this is his signature. He's got a doctorate, my God. And a doctorate knows better and doctors I know aren't sloppy like this. Or their staff that might fix this up, they're not sloppy. But even if it was on a base, even if it was on one of these that they had done before, that they just used as a pattern, my recommendation would benefit from the use of medical to treat their symptoms. They wouldn't be writing a letter for multiple people at one time. So
They wouldn't even have
that's
a
what's odd,
pre-document.
is this isn't even based. We learned this in grammar school, the proper usage of pronouns and see, they even patients, when it's patients, it's apostrophe S, so it's in the singular, but then it's used there in the plural. That's just basic mistake we learned that in English, grammar school, not to do that. That's why I'm always, and then there's not even a period at the end of the sentence at the end. I know you don't, but these are professional. This isn't a professional way of doing things. Not to be critical, but really, this is from the Texas Cannabis Clinic virtual visit. Okay. All right. I don't have any reason to disallow this. This is what you want. But my other condition is, if you want to do it this way, that's fine. But there are other ways of treating issues. But if this is the one you want to do it, your driver's license is going to be pulled. We're going to keep a copy of it while you're on my watch. And you're going to have to get you a Texas ID in lieu of that. All right?
And then how long driving license fees?
Sir?
As
long as you're using cannabis, medical cannabis.
What if I only using?
It's a drug, sir. It's a drug.
Your Honor.
And that's, you can use it, but there's nothing that says you have the right to drive a car with it, with cannabis in your system.
Use it, I don't use it.
That's your problem. If you're gonna use medical cannabis, you're not gonna have a driver's license. That's to prevent you from driving. You can get an ID and it does everything for you except drive. But while you're gonna be accessing cannabis on my watch, you're not gonna be operating a 4,000-pound missile. We've already had problems with that. And people wonder, what in the world is the person using drugs, driving, and killing people for? Well, they were medically, but it's like everything else. You can't operate a motor vehicle under certain drugs anyway, if they're severe, that they can affect your ability to make important decisions operating a motor vehicle. So, some drugs, they say, don't. You've got the precaution. Don't operate heavy machinery or vehicles.
Your Honor, he disclosed his diagnosis. What if he go to a licensed physician that's not prescribing medical marijuana, so he can keep his driving privileges?
Yeah, but it's his choice where he's going. He went to the cannabis clinic. There are other ways that they may be able to treat you. The physician can say, here's a medicine you can take, and it would not be something that I would be disallowing you from operating a motor vehicle for. Okay. But it's your choice. You decide. But if you're gonna, if that's what you're gonna go by, now also we can do courtesy supervision so that you can get a job if that's what you want. But talk to a physician about your condition and what they can do to treat you, other than the cannabis clinic. Yes.
But you got, we're
Yeah.
shit right now. I don't have it on me right now. I'll get it to you.
You don't have your driver's license?
I have to give them a number. I can stop.
Who drove you up here? You?
I drove myself, but I have someone with me today.
Ma'am?
Luckily, sir, I'm sorry.
Sir, I'm sorry. What did you say? I was looking, you were talking, it looks like you were pointing to a lady.
I have someone with me.
Who? Who's driving? You're driving him? Huh? Are you driving him? You broke him.
He rode with me, but he can drive me. Yes. We need your driver's license right now.
All right. Well, you decide. Do you want me to sign this cannabis thing? Is if you do, you can't be operating a motor vehicle. We're going to take a driver's license. Then you're going to have to go get an ID so that you can use your ID for purposes that you need all the time. People, let me see your ID, and you show. Well, then people who don't have a driver's license have
Well, until I get
this DPS ID.
Until I get the proper help, I'll submit my driver's license.
Sir?
Until I get the proper help, I'll submit my driver's license, then I'll go ahead and get it fixed, get it back.
Okay.
I'm giving till 5 o'clock today. Bring it to the court office.
Oh,
If not,
all
I'll
right.
let the judge know.
Let me know.
Not really.
I'll change that immediately.
This is
So you
his, this is for his employment related. His employment is within driving distance of Jefferson County.
And talk to him about that courtesy supervision thing. So if he's trying to get a job in Houston, and
But technically, he's living in Orange County. And I just want to start the process till I
this
discover.
is Westlake, Louisiana,
Yeah, this employment.
but you're looking at something in Houston.
Yeah, my son lives in Houston. My family is in Houston. I'm just in this area.
Well, you can always go, as long as you don't reside there, you can go see them. I'll let you go to Harris County.
But I want to move there too. So.
Oh,
My son,
okay.
he goes to school there. I miss a lot.
Yes, sure. Yeah. All right.
We need
Yeah.
your date, Your Honor. The date.
Yeah.
Today's date. Sorry about that.
Yeah.
And then Jason's. All right, thank you. Your Honor.
Yes, sir. Jason Crosby.
This lady is the one who's been on YouTube. She keeps talking loudly.
I don't hear her.
No, she's muted, but she's saying inappropriate things. If we could do her next. After.
What's she saying that's inappropriate?
She tries to.
When?
Apparently, people have been texting me and telling me I can hear it on YouTube. I don't think she realized she was.
Get somebody in the background.
Oh, it's the background of her? Oh, okay.
Unmute. You, ma'am.
Good morning, Judge.
What is your name?
Jaquil Living.
I can't hear you.
Jaquil
Unmute.
Livings. Oh,
Unmute.
not sure.
Unmute.
It's not showing muted.
Are you trying to talk to somebody on Zoom?
Yeah.
You have to have this on.
Yeah.
Stand by. Stand by. Who is this defendant? Where's that file?
You allowed her to zoom in for restitution and you didn't want her, she got flying in.
I can unmute or try this.
One more time. Try to unmute. Give me a
Can you hear me
test.
now?
Yes.
Perfect.
All right. You were Jaquil Livings?
Yes, Your Honor.
Okay. We're trying to get to you. We only have a 11-page docket today, and you're on page 9, but I'm going to jump to this. We're getting notes from people who are listening to vulgar statements being made either from you or from your position that's vulgarity, because you're on this Zoom, and apparently I haven't pulled you up. I can't hear it, but others are hearing it. What are they saying?
That there were some inappropriate comments and swearing.
Swearing and comments are being made. Who's using vulgar language at that location? That
It's just
people-
me.
What are
Is
you,
my
are you saying, are you making inappropriate comments about what we're trying to do here?
no, sir. Are
Well,
you
that's-
sure it's me? I've
Yeah,
been sitting here.
I know, that's what they're saying.
Maybe you got me mixed up. I'm just sitting here listening to you. What did I say?
Look, I didn't hear that. They're texting.
Yeah,
What are they
like
saying?
3 different people texted.
3 different people have texted to our office.
Am I cursing?
It's cursing from your position.
Oh no. I have a toddler who's homesick and she's in a room, and I have a teenager who's graduated and she's in her room. She just came in to make nuggets for my toddler, but she wasn't talking.
So let's just say 3 people just didn't make this up and contrive this together. Is there any reason that you would be making some inappropriate comments?
No, sir. I'm an hour ahead. I've been up for 3 hours here listening to you. I'm honestly tired. I have no reason to say anything vulgar. And when you say vulgar, what's vulgar?
I don't know. I don't know. I'm not going to spend a lot of time with it, but
Yeah.
that's the problem we have with Zoom and YouTube, is that people have access to being obnoxious when they're not supposed to be. And there's really not much of a way to police it when we're trying to do things. But we do this as a courtesy for people who can't be here. The other,
Exactly.
you come over here and you spend your time to be here, which is what is the conventional method. And maybe that's the way I need to start doing things. And that will keep that sideshow from occurring.
Right. No, I'm totally appalled. I'm here for a reason, and
now-
vulgar is not. I'm confused as to what vulgar language I was using. If that's the impression.
Well, vulgar or inappropriate, but when you're
That's not my character. So
well, the 3 different people are mistaken. So
right.
You the probation officer?
No, sir, I have.
Skata.
Yeah, I've been taking care of it since Mr. Harmon's retirement.
All right, on this case, let's see, it's a restitution issue?
Yes, sir.
Where are we on?
As of today's date, Ms. Liggins has a remaining balance of $5,532.
How much was it at the beginning?
15,000.
Okay, so she's paid 2/3 of it.
Yes, sir. She's
already.
paid $9,000.
How much is she paying a month?
$102.
Okay, so that still gives 4 years
Yes, sir.
plus. All right. Are you employed, ma'am?
Yes, sir. I'm at a local hospital. I do newborn hearing screens.
How much are you able to pay a month because all things being the same, is this the only thing holding her up on probation? Restitution payments?
Yes, sir. She's on inactive probation,
Yeah.
but the restitution would be the only.
Okay, you've got $5,532 left to pay.
Yes, sir.
How much could you pay a month toward quickening the end of this?
I've been making 100. I can bump up to 150. Last year I've gotten 2 out of high school, got 1 in school, and health. I've been making less payments than wanting to. So
That would give you, that would probably complete this in 3 years. So that cuts down 2 years or so.
yeah.
All right. So
Actually, I'm trying to be done with this. I've been back and forth this for a couple of years, so I'm trying to be done with this. Hopefully by the end of next year.
what we're going to do then is amend the probation order to order you to pay a minimum of $150 per month. You can do that without objection.
Yes, sir, not a problem.
Probation officer will prepare that and get that processed for you, okay? And then we'll
That'll work.
have it. Anything else on this one? Because I got other things. Okay, that is all. Thank you.
Thank you so much. You guys have a good day.
And, Jason Crosby. I have a Jason Crosby, no answer in the courtroom. I asked the bailiff to call into the hall for Jason Crosby.
What would you like to do in case it hurts so much?
I don't know, is there any way we can back some, but we can put it in there, she's on the court reporter's notes that said she did it.
How many?
I don't know. 6 months. Okay, Jason Crosby. There is no answer in the courtroom, no answer to that name being called into the hallway. Defendant has failed to appear. The court will note that there are, I'm getting from Mr. Crosby's last purported address, the mailing showing, yep, no one is at it. No one, it is returned insufficient address, unable to forward. Then that's the most recent one, a 990 Cypress Station Drive in Houston. Then there's one that was the previous one, which also showed unable to or insufficient address, and that was 305 West Baker in Baytown. What does probation show?
And then, that 305 West Baker Road, apartment 1605.
It doesn't say any apartment. It says West Baker. See, maybe that's what needs, there was an apartment number that needs.
Took the address off the bond that he made out of county when he shouldn't have, and I mailed it to every other address that I could find for him.
Okay.
I believe I sent out three
There's-
separate notices of the court date this time, plus the bonding company.
All right, the defendant has failed to appear on this motion to revoke probation. I guess a warrant is issued for his arrest is all we can do.
Yes, sir.
He made bond out of Perry County.
He didn't show up today, so his bond is revoked. A warrant is issued for his arrest. Is there any way, do you have any do you communicate with him by phone by any chance?
I haven't. He's been refusing my phone calls because he know he had this active. Well, he's been refusing my phone calls.
Okay, this is a regular probation, so there is no bond. There will be no bond on this. Warrant is issued for his arrest for failure to appear. Thank you. Then Keenan Dancy. Keenan Dancy, please. 13-16513. There is no answer in the courtroom. I asked the bailiff to call into the hall for Keenan Dancy. All right,
He's paid off his reputation.
he did.
Yes.
So what are we going to do today?
Our recommendation was to
Sit down. Sit down.
dismiss.
Who is that?
I don't know, but he was walking up.
Who are
there.
you? Are you related to this man?
No.
No, I don't know him.
Good, okay. You're Mr. Dancy
Yes, sir.
and from probation?
To dismiss his motion and allow his case to close with the remaining.
Any objection to that?
No, sir.
It's done. Congratulations, sir.
Okay.
And thank you for doing well.
It only took him 50 years to finish. He was not what I was expecting for the defendant.
All right. Yes, sir. I will be happy to sign that when you get that to Catherine Furlow. 38340, Catherine Furlow.
Sir, come out this way. Sir.
Yeah, this is good. Sir, no, sir, no. This way. He needs to go that way because that door's locked. There we go. Thank you. Yeah, that's the only door that's open, sir. Yeah. Thank you. Bye. Catherine Furlow, please. 21-38340. All right. you or Captain Furlow,
Yes.
and you're on probation here,
Yes.
since 2022, what that last motion dated November of 2022, we had all kinds of changes to it. But it was, let's see, failed to report. And you have been placed on 10 years deferred or unadjudicated probation. And an administrative hearing was held. What's the status of everything here on probation? Is she doing well or not? Mr. Brooks?
She is, Judge. She's doing well. As I understand it right now, her job is, a little bit.
Transitional?
She's not getting as many hours, so she's not making, she's not able to make the payments that.
Funny, I'm getting too many.
Yeah.
Go figure.
Right. But, overall, as of right now, she seems to be doing.
How do you think you're doing?
I think I'm doing pretty good. I'm just,
What do you need to successfully complete probation?
well, actually, I'm, looking for another job, because they are, doing things with like my hours.
Yes, ma'am.
So I'm trying to.
What do you do?
I'm a home health aide. And
Okay, there's got to be a need for that.
Yeah, it is. I
Okay.
I start a new job, hopefully, a second job, Monday.
No. So what should we do today? Sounds like she's doing fine. I don't want to disrupt it. Let's move forward and see if she can get a better job with some more income. Yes. You were going to say
Yeah,
something?
and there was some question about whether some insurance had paid some of this restitution, but I know that the court still wants insurance company possibly paid back, but because the restitution still owed is over $44,000.
What is the status of that? Do you know? With your insurance company?
I've been trying to get hold of them and they haven't been, my lawyer, that was my lawyer when I had the.
Who was that?
It's in my phone.
Okay. Well,
Really, I'm never trying to get information.
is the lawyer in this case?
Yes, well, she's in the, I guess for the other, the persons involved. Well,
Oh.
she's my lawyer, but he has a lawyer as well.
It's on the civil case?
Yes,
Yeah,
on
okay.
the civil case, I think all state.
Okay. Well, you need to get with them to see where things are, but your probation order includes restitution, which was to be determined.
We determined,
And
Judge,
we determined it to be.
and it was ordered. I don't know. Yeah, it was $44,516.57. Without my glasses, that was pretty good.
Well, that's real important to purge all of this. What do we do next? Review in 6 months?
Sounds good.
Yes, sir.
Okay, thank you. Please get a resetting in 6 months. Mark Thibodeau. Mark Thibodeau, please. Nice outfit. I mean, this court. I mean, this is an important thing. Would you, we're not church, but would you wear that to church?
I don't know, sir.
Why not? Why not? Yeah, because it's not appropriate?
T-shirt it is. sir.
What do you think?
I'll
The Friday the 13th slasher is what is appropriate. I mean, this is important. This is your life. This is the Constitution, liberty. And you're looking at serious offense, a second-degree felony, and what's the other ones?
outgrew my suit, I'm sorry.
Huh?
I said I outgrew my suit, I'm sorry.
Well, look, I'm on the board of the Salvation Army. If you need clothes, you can get some clothes anywhere, and they're nice clothes. These are second-degree felonies, and you're looking at up to 20 years in prison on each case. And I just think that's a better way to dress, to show respect to the whole proceeding. Or you don't have to, but it just shows that you don't have much respect for the way this is operating. But nonetheless, you're looking at 40 years, up to 40 years in prison if you add all this. I would find that serious. What's the status now?
So since we last met Mr. Thibodeau, he has registered with local law enforcement. He's entered sex offender treatment with a licensed treatment provider. He has gained employment with McDonald's Mechanical Services. I have the 2 letters of apology ready to send, and I did get a substance abuse assessment completed
A
on
what?
him. A
Which one?
substance abuse assessment. The recommendation was frequent UAs, and if he's positive, to refer him to JCDI.
He's passing all of those.
Yes, sir. He
Yeah.
tested negative.
Are you working somewhere?
Yes, sir.
Where?
I work for McDonald Mechanical Services. I do HVAC,
Okay. How much do you make an hour on that?
$28 an hour, sir.
How much?
28
Well, it's 70 grand a year.
plus 2, yes, sir.
How are we doing on fees? Is there,
He has made a payment of 125 this month. I do need to get his time served taken out of his balance.
okay. How long have you been working for them?
For about a little over maybe 3 weeks now.
3 weeks?
Yes, sir. I had a job like the second week out when I got out of prison.
Well, okay. Well, you'll be able to afford some better clothing, huh?
Yes, sir. Yes, sir. I'm sorry. Like I
Well,
told
it's
you,
just,
I
that's,
mean, it's unexcusable, I understand, but I
Yeah.
promise I'm not gonna get it.
and when people say we don't have clothing, yeah, well, Salvation Army has very good clothing. And
Sorry.
that's okay. Should we do next?
I'm good with the frequent UAs just to monitor his use, and if he does, I'm perfectly good with JCDI. But we can review in 6 months for his.
All right.
use.
But or the JCDI, is that what's already ordered?
He's not ordered to do that, no, sir.
Okay, are you saying do that or not?
If he tests
Or
positive,
If
yes,
he
sir.
tests positive, okay. All right, well, that's a carrot out there that should motivate you to avoid testing positive.
Definitely, sir.
Okay,
Nothing
you get a
against-
resetting 6 months. Yes, sir. Joseph Ledet or Ledet, there is no answer in the courtroom. I asked him, okay, on Mr. Ledet's, is it Ledet or Ledet?
Ledet.
On Mr. Ledet's case, this one, what are we dealing with today?
Fees.
Hold on, I'm gonna ask her.
So in January, Mr. Harmon asked the court if his MTRP status could be dismissed and his probation be allowed to expire with the fees due to his medical conditions. And there is this.
Yeah, I guess what I probably misunderstood is I'm reading this fast and he did successfully complete another case where he paid all fees, including restitution, which probably is what caused me to say, oh, no problem here. But it's restitution. People who are harmed wonder, what in the world? Are they getting released? They owed me, but they didn't, so we're just gonna dismiss and not even find him guilty on anything. Which is, if I were them, I'd wonder what's fair too. It's great. We dismissed that other case already, right? 10243. I did sign this. But I gotta tell you that I didn't realize there was still restitution ordered of $4,927.88. What do we do with that? I mean, that's just, I'm sorry about it, but the people have to get paid back somehow. Are you able to pay these people back?
Yes, sir. I've had some health issues, and since that letter, that signature was placed on there, I've had another amputation, so I'm a bilateral now. So I've just a lot of serious medical expenses come up, but I can move forward. I can, to the best of my ability. Yes, sir.
Well, how much is it you could pay toward this? Because I don't want, he doesn't need to be on any other kind of probation condition at all. I don't want to, he's in an active, yeah, all you just pay and as long as you can pay what you can.
Okay.
Then these people get, we're not going to revoke your probation. We're going to keep it open as long as you can in good faith pay.
Okay.
How much do you think you could pay a month?
I want to commit to 150, Your Honor. That's
All right,
okay.
why don't we do that and let's start working toward that, but we're gonna keep this open if that's all right.
Okay, so.
Otherwise, you don't have any other obligations except to make regular payments, and she'll work with you on getting something shown that you make at least 150 a month.
Correct.
As long as you can do that, then, and we'll just review it in about 6 months to see where he is financially, okay?
Okay.
All right, thank you, sir. Garrett Scott, that's you?
Yes, sir.
Come on up, sir. Looks like you're on probation for 3 cases, correct? How we doing on, yeah, no, not good. What? Looks like, we've got some, a new crime here, criminal trespass. Occurred here in August. Missed a curfew, behind on restitution. You were arrested by the police department at 10:16. Aren't you, you're on probation. Generally, you have a curfew at 10 p.m. Let me see what that probation order says. Uh-oh, be inside your home every day between 10 p.m. and 6 p.m., which meant if that was being followed, you wouldn't have been arrested at 10:16. All right. Then I don't think we have a choice here. We got to move forward. He's on probation on 3 cases?
Yes.
All right, then are we asking for a motion to revoke probation be filed in each of these?
Yes.
All right, please do it. I'll sign it and then we'll move from there and we'll see where it heads, okay? Thank you. You need to follow your probation terms, sir, or else you have to pay a penalty like anyone else. No, ma'am? Are you the defendant or somebody? Okay. Were you involved with the arrest at 10:15 in Port Arthur? Yeah, were you there? Yes. You were there in Port Arthur? At the time, what were you doing there? What? What were you doing at the time at 10:15? When, yeah, that's your house? Okay. Why was he arrested?
He arrested at my house because I think he broke into someone's car.
Uh-huh. Okay, we gotta resolve that. We're gonna have to resolve that and see what the deal is on that. Cause you can't be committing crimes while on probation.
Want to say you can't work until you get started.
I'm not asking about work, I'm asking about crimes. Well, yeah, he can't be committing crimes. Yeah. Brittany Sylvester, please, 38966.
She called yesterday and told me she wouldn't leave it.
Why?
Gosh.
I am pro se. My name is Brittany. I informed Judge Stevens that I am pro se, spoke with Judge Stevens a couple, and I was told there would be no case in my name and that it is dismissed and I am the trafficking victim who was attempted to be kidnapped. What the world?
So you had ordered for her to have a competency. She had went to school talk, but she was not, she told them that she didn't need any medication, so she only goes here like.
Okay, Brittany, well, she was required to be here. Okay, 21-38966. There is no answer in the courtroom. I asked the bailiff to call into the hall for Brittany Sylvester. Now, this motion, she pleaded true to, failing to report back in December, right?
Yes, sir.
Did she report to probation?
The last time I seen her was May 28th. She stopped reporting that letter
Why?
that you state that you read is basically what she told us.
Why? Why do you understand
The same reason she said that she called the office and they told her that her case was disposed and she was adamant she was no longer on probation.
Okay. All right. What I'm going to do is ask for, well, there's a motion already filed here that she pleaded true to. I guess we add failure to appear.
Yes, sir.
As required in a first amended motion. And then we'll send it out and then we'll have to deal with it when it's executed and she's arrested. And then we'll bring her in then and see what the problem is. I've got Carl Solomon.
Mr. Langston, earlier and or whatever.
And what?
They called him and then Langston left, so I don't know
What happened on, what did we do on that?
I don't
Your
know.
Carl?
Yes.
He wasn't here at 9 or earlier from Langston.
Okay, what I'm gonna, where are we on this?
So since he obtained his drug patch, every document that I've got from Johnny's, he's tested positive.
Okay, we're gonna test him right now. And I've got, get in the box right there, sir, thank you. I've got, George Collins Jr.
Gentlemen with the license that you took, they'd like to speak to you again.
Yeah.
Let you know they real.
Huh?
Who relinquished his license?
Okay.
It's in the file.
Okay, you can always have it back when.
You
But
establish alternatives. Okay.
yes,
All right.
yes, sir.
That's
Thank
what
you.
He actually brought his driver's license back and dropped it off with the judge so that he could continue to use his marijuana because he got medical marijuana permission. And the judge was like, no, you chose to go to the marijuana clinic when you could have gone to a physician's clinic. So if you're going to choose the medical marijuana clinic, I can't stop you, but I can take your driver's license away. And that's what he did for as long as he's on probation and using marijuana. The judge will not allow him to drive. But the judge said, go to a physician's clinic and see if they can help you, and we'll talk then.
No, thank you very much.
Thank you.
Great. Thank you. See you later.
That was George Collins, huh?
Yeah.
You're gonna get this to him to complete the order. Anything else? We are in recess. Do we have another?
It's being tested.
I gotta go right now. We're gonna have to, he's gonna have to, what do we have? Something at 1:30?
No, sir.
Oh, nothing further? I've got a appointment at 12:30. I'll be back though. At 1:30. Who's being tested? Him? How do you do?
I think that you good.
Yeah, he's on the way.
All right, I don't have time. I gotta meet I have an important meeting at 12:30. You need to stick around. I'll be back at 1:30.
Yes.
Okay. Here, take this care of this.
Good.
And
Should we put him in custody?
if he tests positive,
But right now, what do we need to do with it?
just keep him right there while so the person's gonna come in and test him.
If he tests positive, what should we do?
We're going to put him in custody until I get back, and if he tests negative, he's released.
Okay.
And he needs a resetting done.
It was about, I don't know, 90% of Steven's docket. I cut out the really boring stuff. I'm exporting, I removed the watermark from the judge's face, and I'm exporting. Oh man. Oh, it'll be fine. I'm hoping to use Canva, and I'm hoping it allows me to crop the video. I don't know if it will though. I don't know. But for my replay crew minis, I don't want the judge's face covered. Ugh, I hate making mistakes like that. That's a big one. I've been a little distracted though. It'll get better. Thank you guys for coming out and being with me tonight. Be safe, be well, sleep sweet, and much love.